As per order to 11/2/25, there is interim.
And a request for review petition at least after 3 weeks. Interim be continued till next date of listing.
Deeply.
May I please, Your Lordship?
Yes,
Item number 21, kindly adjourn for this day.
21.
Yes.
Adjournment for a
This
week.
day.
Huh?
For this day. This day, madam.
Acha, list after 2 weeks. And the request made by Koiriva. Okay.
Obliged, madam.
Lordship, item number 39, page diary not available. Earlier interim order passed by this.
39.
39,
Interim was there.
interim.
CD not available here. What happened? CD not available. Issue reminder. Interim be continued till next date of listing. When it can be fixed? What happened?
22nd of April.
22nd of it.
Yes.
May I please, Your Lordship? Lordship, I'd like to mention item number 52 for adjournment. Lordship, my senior is not well, so kindly, matter may be listed on second week of April.
Who is Mr. Mohanta?
Hmm.
Mr. Mohanta to is not keeping well bill likhi diba. Amicus is there, Mr. Yes, you are the amicus. Amicus was Mr. Esdas. Considering the submission made by the learned counsel for the petitioner, let the matter be listed after 2 weeks.
May I please,
May I please, Your Lordship? I'd like to mention item number 36 and 37. I'm for the 37, madam. I'm for 36, madam. Today, madam, some difficulty I paper on Monday, Lordship. You want 36.
36 and 37.
On Monday.
You are on 36.
I'm for 36. I'm for 37, Lordship.
You are for 36. Here, case diary is here available.
Not, madam, this is LCR, madam. LCR, madam, not reflected, but LCR received, madam. I have inquired.
LCR already received.
Received, but not reflected. On Monday, madam.
Monday not possible.
Monday, madam.
Before it not possible. Monday can it be possible? No, I don't think so. Tuesday pariba. Many matters are there on Monday.
Only, madam.
Many fixed matters are there in fact in Monday. Huh?
On Tuesday, madam, there is a debt defense case, madam. My senior is there.
I don't know. Monday is not possible. Wednesday kiman tarik? At best Wednesday, 26th.
Madam, when is it?
may I please, Your Lordship? I'd like to mention item number 13. Adjourn, kindly adjourn for the day.
At the request made by the learned counsel for the petitioner, matter is adjourned. List after 2 weeks.
Lordship, it mentioned for the previous bail for Mason listing.
Listing of a
ABH.
make a mention before court number 3. Court number 3, it may be listed here, but court number 3.
May I please, Lordship? Lordship, in item number 47, we have filed an additional affidavit, my lord. That may be called for, my lord. And my lord, the other prayer is that, my lord, after motion matters, my lord, this matter may be taken, my lord.
What is your prayer? 47?
47, my lord, we have filed an additional affidavit that may be brought on record, my lord.
This is in the admission column.
Yes, no, in orders column, my lord.
So, no, after motion, it not be possible.
But some
Affidavit,
urgency,
we are calling for the we're calling for the affidavit.
some urgency is there, my lord.
No, we cannot take it. Bail as there.
Deeply.
Okay.
May I please, Lordship? Back to item 40. Can you pass over the day, the interim order? Any date for the next week?
14 in the motion column. 14.
40.
40.
Bail hearing. ABM.
You have received the case diary. CD is written for it. Was there any interim?
Interim order.
Interim be continued till next date of listing. When it can be listed, what happened?
So,
It is on 26 CD, CD on 2nd of April.
The interim is there.
Okay, interim be continued.
May please your lordship. Lordship, in connection with item number 35, we filed an additional affidavit yesterday, my lord, to bring the notice under 47 on record. That may be called for, my lord.
35,
Item number 35,
additional,
additional affidavit, my lord. Yesterday filed. Oblige, my lord.
35 or additional.
Yeah, please, Lordship. I become a mention item 29, Lordship. Well, agenda matter for today, Lordship. CD is not received, Lordship. 29.
29.
Yes,
29.
CD scan copy has already been
the
received.
CD is not received, Lordship. I've seen the record, Lordship.
Acha. Also, CD was also called for along with the case diary, case record. You're Mr. Gogol,
Yes, please, GD.
heard Mr. G.G. Gogol, the learned counsel for the petitioner, and also heard Mr. P. Bhattaku, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Gogol that CD, though the case scan copy of the case record has been received, but CD is not available. Is the issue, the registry is hereby asked to issue reminder to call for the scan copy of the CD and the present status of the case record. List accordingly after 2 weeks.
Afterwards.
May I please, your lordship? I beg to mention item number 44. Lordship, as per office note, it shows service report is awaited. But I have some information that the service has served respondent number 2.
So let the matter reach, then only we'll see. We are not having the record now.
Up to date status report may be called from registry as of today.
Okay, we'll see to it.
Oblige.
May I please, I beg to mention item number 43, madam.
Yes.
Kindly adjourn the matter for 2 weeks, my lord.
CD is available. For 2 weeks, my lord, it will be difficult for us to retain the case. On my lord, 1st of April.
First, second, third, lots
third
of
of-
matters. First, second, third only.
Third of-
Third can be. Instead of sector, she is saying that second can be. 2nd of April. We are retaining till 2nd of April.
Yes.
Are you on interim?
Yes, ma'am.
Interim be continued till next date of listing. List accordingly on the 2nd of April. CD be retained till next date of listing.
Oblige.
For withdrawal, item 1. Will to withdraw as per instructions.
Lordship, as per.
As per instruction, Mr. S. Munir wants to withdraw the paper. It will be disposed on withdrawal. Otherwise, he is in custody still.
Lordship. They might appear, approach session board.
Okay, it's fine. Disposed on withdrawal. Item number 2 also same.
Same.
Out of same FIR, this to know.
No, different.
But you got the info, I mean, instructions.
Instruction.
Same order as per instructions of his client. Wants to withdraw the same. Disposed of on withdrawal. Okay.
Much obliged, your lord. Much obliged. Much.
Item 3.
May I please, my lord? My lord, this is charge sheeted case, my lord. LCR may call for my lord. This can copy of LCR. And my POXO is there, my lord. Notice, my lord.
Foxo is also there.
Yes, my lord.
You made party to the
Yes,
informant.
my lord.
বাকি লিখিব issue notice কৰি দিব and the respond number
2, my
2 to judicial police station routed to the office of the registry and the public prosecutor. Also call for the case diary. Oh, sorry, it's a case diary or
LCR.
charge sheeted.
LCR, my lord.
Scan copy of the LCR along with the case diary. List accordingly, it may take some time to
10th of April.
9th of April. To 9th of April.
Oblige, my lord.
Item 4.
May I please to my lord, this is a bail application under the 483 BNS. My lord, can you see the FIR, page number 2020? The petitioner is arrested on the 3rd of February, and as of today is around 50 days in the jail. The seizure list is page number 2020, the seizure list. The quantity is very small. Actually, there was a dispute between the wife and husband. Wife went to police station and complained that there was some cannabis. Someone has kept some cannabis in his house for the Shivorati purpose. So as soon as the police heard the information, they went and they checked it and they got it. It was below 1 kg, but on record it has put 2 kg, 836 grams. Just about the intermediate grade.
Yes, Botakot.
My lord, I can produce the case diary on 24 or 25th.
24 is Monday. Monday may not be possible, I think. 25th.
Because already 15 days is in the
That's why I'm saying this, just this shorter date can be shortest, I think, not shorter, shortest. 24 may not be possible to reach the case diary. That's why we are fixing it on 25.
My lord.
Okay.
Ajay.
Item 5. Yes.
483 application. FOXO is there. Section
FOXO is
6 of
there.
FOXO. Already, 77 days in custody. As of
Already 77 days.
77.
Okay, same order, issue notice to the respond number 2 through the Judicial Police Station and routed to the office of the public prosecutor and the registry and the public prosecutor. Also call for the case there. He is in behind the bar for 77 days.
Around 77 year old. He fixed on
Yes,
third year old. Statutory will be over by third.
Third may not be possible or let it be on
4th of April.
4th of April. Okay. 4th is, okay. Then.
Right.
Item 6.
May I please? Please. This is an application of 8 of FOXO. Affair page number 15 matter. Main vernacular matter. May I read you?
No. Now since when he is in custody, just tell.
Since 13 to 2025, 36 days custody. 60 days is the mandatory period.
But we have to issue notice. That is the main issue.
Yeah, victim, my lord, in this case, you're not, he's a boy, you're not 14 years of age.
Whatever.
Yes, ma'am.
Whatever. Boy or girl, boy is also under FOXO. It's not that
Yes,
it's only girl.
Thing is that.
So
my
Dimpi
30
Bora, Srimati Dimpi Bora is the informant.
Yes, madam.
Mother.
Mother.
Okay. Yes,
36
mother.
days in custody, madam. Considering that, madam.
When it can be listed, same order.
4th
From
of
Issue
April.
notice for you, same order.
CD, my lord.
2nd of April.
2nd of April. Okay.
Review of this.
7.
May it please your lordship. So this is an application under section 483 of the BNSS, your lordship. FR at page 8.
Page 8.
Page 8, your lordship. And the allegation is that, my lord, from the petitioner's mobile, my lord, some messages went to the informant's mobile, my lord. Then they see that my messages were vulgar in nature. This is the allegation, my lord. Page 8 is the FIR. May I read, my lord, or not? My lord, with due respect, I beg to state that I, Gita Mandal, Deka, wife of so-and-so, is a permanent resident of so-and-so, and is a lady engaged in different social works. Sir, I beg to mention here that from last 6/2/25, an unknown person from his mobile number so-and-so is sending messages by using slang languages in my WhatsApp number. The language of the message are so vulgar that I became ashamed as well as humiliated. The above noted person uses my photos and my daughter's photo along with the message. As a result of the daughter also became ashamed. Therefore, I have lost that. This is the allegation, madam. Now, my lordship may kindly see. Lordship knows I have discussed one matter elaborate. Lordship knows, madam, regarding the notice, madam. When he was arrested, madam, case 20, madam. Madam, here, madam, lordship, one small case, madam, that a person whose leg was amputated. I discussed the matter. Lordship is that madam notice, madam. Here, madam, no grounds of arrest has been assigned. Page 20, I have annexed a certified copy also. That is at page 22. While he was arrested, my lord, probably processed, my lord, it is clear, my lord, that no grounds of arrest has been assigned, my lord. So, my lord, and the allegation is that only some messages were sent, my lord. He is in custody, and moreover, my lord, if we believe the allegations are true, my lord, then the 67 IT Act will come, my lord, and lordship knows, my lord, it's a
Where is the seizure list?
seizure list, my lord.
No, the mobile has been seized or you're not?
Yes, well, page 16 is the forwarding report.
Mobile has been seized, my lord.
Mobile seized.
Mobile seized, my lord. And my lord, if you believe also, my lord, if the 67 of the IT Act will come, my lord, lordship, it will be bailable, and my lord, possibly when the other section may not be attracted, my lord. Because my lord, electronic device has been used, my lord, for my lord, if you believe the act has been done, the crime has been done, my lord, it's with a electronic, my lord, media, my lord, then my lord, IT Act will cover, my lord, and lordship knows, my lord, that my lord, when offense is my lord, covered by an IT Act, my lord, the my lord, in my lord, Saurabh Babu Digamut, I have page 6, my lord, I have my lord, given the citation, my lord, where it is clearly stated, my lord, that when the act covers an IT Act, my lord, the IPC may not be there, my lord. And moreover, the notice, my lord, without assigning any grounds of arrest, the notice has been served.
Since when he is in custody?
He is in custody since, my lord, 6-3. 6-3. My lord, may I pray, my lord, further custody may not be required, my lord, because it's my lord, if we believe that my lord, the notice has been served without my lord, assigning reasons, my lord, without grounds of arrest, my lord, it's a illegal detention, my lord, not a probably procrastination. If lordship, my lord, allow my only 2 paragraphs, my lord, lordship has seen earlier, my lord, in one of my cases only, that Rahul Adarika, the person's leg was amputated. Sir,
Grounds of arrest is already as specifically mentioned in page number
my
16.
lord, that is forwarding report. My lord,
And
forwarding report is not with the accused. It is submitted in the court. Forwarding report will be there, my lord, but it is the forwarding report, my lord. Yes.
Your lordship may kindly peruse page 16. He is a healthcare offender, my lord. Earlier also, he is involved in committing the same kind of, my lord, offense.
Earlier also.
Yes, my lord. Specifically mentioned, my lord.
Here, my lord, paragraph 19 and 29, my lord. Lordship has earlier dealt with, my lord, that no, my lord, without grounds of arrest, my lord, no. There should be specific grounds of arrest mentioned, my lord. Paragraph 19 and 29, my lord. Other judgments are also there, my lord, but my lord, this is wrong. I have annexed the certified copy also, my lord, of the 2 notices, 47 as well as 48. But forwarding report grounds of arrest will be there. It is not served to the accused. It is placed before the court, my lord. And 16 days.
No, he is here, other cases also in earlier?
My lord, that information I don't have, my lord. But see, here, my lord, in the forwarding report, it is my lord, not clearly mentioned the other case numbers also, my lord. And my lord, further custody may not be required, my lord, because if you believe 67 IT Act covers, my lord, it's a bailable section, lordship knows, my lord.
There is a provision that if IT is applicable, then may not be the other
In
section.
that
But the
case,
question is that
earlier also, I will also point out to your lordship, because the matter is today fixed only for motion stage, my lord. My lord, IPC and IT, my lord, there are also decisions of this. Well, I will point out to your lordship, at this point of time, my prayer before lordship, let the city come and get the report whether the petitioner, as because it is specifically mentioned that he is also involved, habitual offender, involved in similar kind of offenses earlier also. Let city come, my lord. At that point of time, I'll argue on the point raised by the petitioner, my lord.
My lord,
The short date may
if
be fixed,
habitual offender also, my lord, but and particular in
Any
this
short
case,
date may be fixed, my lord.
in this
On
case,
that day, I will.
and regarding notice, my lord, whether any, my lord, it's a condition precedent, my lord. The grounds of arrest should be there in the
Otherwise,
notice,
my lord, IPC, my lord, there are specific
my lord.
offenses
But
under.
my lord, apart from that, my lord, the notice issue, notice, my lord, notice there should be grounds of arrest, my lord. And Saurabh Babu Digamut case, my lord, it is clear. Honorable Apex Court has clearly said, my lord, that, my lord, when IT Act is there and electronic media has been used, my lord, my lord, that IPC may not be attracted, my lord. I quoted the specific line.
tomorrow, I mean,
On Tuesday, your lordship may fix on that day, my lord, I will get the case diary and I will point out to your lordship on the grounds raised by the petitioner, my lord.
Tuesday. Okay, then Tuesday. We are fixing it on Tuesday,
Lordship.
25.
Along with the case diary, my lord.
Along with the case.
No, I'm deeply obliged, my lord.
CD call को তো এটা রাখো will prove custody.
Item 8. Hey, please, your lordship. 483 BNSS application matter. Here is the offense is 21B. Recovery is 31.61 gram of suspected heroin with container. There is no
Since when
mention.
he is in custody?
Petitioner is custody since 27 days, as on today.
Yes, Botako. What was the quantity you have said?
Uh,
30.
0.61 grams of
31.61
weight.
grams with container, my lord. There is a 25 plastic container, but they have not mentioned the actual weight of the.
While forwarding, is there any mention about the actual
No,
weight?
no, actual container is not mentioned, my lord. With container, they mention. It
At
may
the
fall
time of
under small
this
quantity.
preparation of inventory and all, it may come,
Yes,
Botako.
Yes.
So he is behind the bar since last 27
7
days?
27 days.
Yes.
On 4th of April, I can produce the case.
Court, yeah,
No.
lots of matters.
Well,
huh?
Then on 8th of April,
My lord, next
Seventh,
week, next
seventh.
week.
or
or
7th,
eighth.
yes.
My lord, next week, please.
It's not at all possible. Before it, prior it, we have fixed lots of matters because all are requested for prior it. How to deal with every have to peruse the case diary and all. So 7th of April,
It's from Jalukbari PS.
I know, but we don't have space. That's what I'm saying. 7th of April, we are fixing it up.
Then 4th, my lord, please.
Court almost full, in fact. Fixed matters are, lots of fixed matters are there. That's why. Otherwise, what will be the reason? That's why I'm fixing it on 7th. Okay, 7th of April.
That day it would be easier for him also, my lord, on the ground of length of detention.
7th of April.
Okay.
9.
So we make it rather, please.
Under section 483, my lord. NDPS updated case, my lord. Kindly call for this scan copy, my lord.
It's a charge sheeted one.
That's it.
Charge sheeted case, call for the scan copy of the case record along with the case diary. Registry will do the needful in calling the case record. Here also, can we fix a date or after 2 weeks? Let it be after 2 weeks, will do.
My lord, date may be fixed, my lord.
We don't have dates, in fact.
But then after 3 weeks, my lord.
After 3 weeks, I need a date only.
Lord.
3 weeks of give a date, 24, 24/4.
Obligator, sir.
Item 10.
May I please, your lord?
Yes.
Originally, কোনটাকে arrest হয়েছিল, sir?
Original 22 তারিখে first arrest.
My lord, in this case, my lord, this petitioner, he was originally arrested on 22/2/2025, my lord.
22/2.
2000.
Why originally means 2 cases are there. Oh,
There
it's
are
the
lots
case
of
of
cases.
shown arrest also.
This is shown
Achha,
arrest,
achha.
my lord. In the first case, he was arrested in 22/2025. And there is one more case on the same day. Again, he was arrested in same day. That is also in 22/2/2025. That is in Pathorkandi, my lord. One first case was a 54 of 2025. Second was is 55 of 2025. Pathorkandi police station.
Both are from Pathorkandi police station.
In the original 2 cases, Pathorkandi police station, madam. In the first case, the bail was granted on 3/3/25, my lord. That is the page number 87,
31.
page number
31.
31, my lord. Bail was granted by this honorable court as there is no compliance of 4750, my lord. And the second case, which was shown arrest in the Pathorkandi, that case also, we have moved before this honorable court. And the bail was also granted in that case on 11/3/2025. This case is very important to adjudicate this particular case. My lord, in all the cases, there is a similar kind of affairs, my lord. I'll come to the FIR, all the cases, my lord. Now,
Lordship, kindly turn to the second case, second FIR, registered in Patharkandi. Page
55 to 55, second FIR. Page 20.
page 29.
29. This is the FIR of second FIR. no?
This is the second FIR. First FIR also content is same. But I'm coming to the second FIR, which is more elaborate. Page 29. With reference to the subject cited above, I have honor to draw your kind attention to the law and order situation that did arise at the Central Public School, CPS Patharkandi on 21st October 2025. After the conclusion of the second 12th standard examination, the CPS is the CBS affiliated school providing education up to 12th standard. The school is promoted by Educational and Research Development Foundation, ERDF, based at Guwahati. The foundation also ran a private university named University of Science and Technology Meghalaya, shortly USTM. The Center for 12th Standard CBSE examination students, the CPS Patharkandi and the nearby Adarsha Vidyalaya Lowarpara were allowed there. The 1st February 2025, the physics paper total 275 numbers of students appeared for the examination. Out of 275 numbers of students, 15 numbers were from the nearby Adarsha Vidyalaya and 45 numbers of students were regular students of the Central Public School, and the remaining 214 numbers of students who are enrolled in Vision 50 under ERDF. It is pertinent to mention here that the students of Adarsha Vidyalaya Lowarpara and the regular students of the Central Public School did not partake the protest. The law and order situation was mainly caused by the remaining 214 numbers of students who were not part of the regular classes in the Central Public School at Patharkandi. All the students are mostly juvenile. Their protest was carefully handled by their grievances as headed. These students alleged that they belong to the different parts of Assam and had come there to appear exam. They were promised by the school authority, Lordship kindly mark, its school authority, that they would help the students in passing as well as enhancing marks the adopting the unfair means. Few students also alleged that they were demanded monetary gratification by the authority to help them to pass the examination. To our surprise, it is found that 214 numbers of students never did any class in the CPS Patharkandi. They came here only for the 12th standard examination, and it was promised to them by the authority that they will, it was their own center and it will be smooth and convenient for the exam, them out in the flying colors and adopting the unfair means. These 240 numbers of students were doing coaching classes at USTM campus under the aegis of the Vision 50 project and entrance into the medical and engineering examination. Many of them did not even know that they were enrolled in CPS Patharkandi. They were kept in dark by the authority, as well as some of the students are transferred from the Vision 50 Guwahati by means of deception with the promise to help the forthcoming exams. These students have created law and order situation when did not find any assistance. Now, logically mark it, these students created the law and order situation when they did not find the assistance forthcoming, which was promised by them by the authority. So when authority did not allow them to cheat in the examination, so then they have protested that we are not allowed to cheat in the examination. That is the crux of the first information, the first FIR also. As the authority did not allow to take any unfair means. That is the grievance of the students, and because of the authority did not allow, so this is the case, madam. Apart from the few students also alleged they have been promised by the USTM authority to clear them out in GENET examination conducted by NEAT to get the prestigious medical engineering colleges and with good quid pro basis against the money. It is also safely suspected they will also facilitate unfair means in the clear competitive examination related to various jobs. Therefore, it seems it is a case of massive criminal conspiracy having large sinister design USTM authority by the Mahbubul Haq who is the petitioner before your lordship, has been a part cheating the student by making the false promise to them, criminal breach of trust, and the forgery. However, they have been part of organized crime by facilitating mass cheating in the examination, thereby jeopardize the sanctity of the examination. Father of many students also they have requested register so and so, so and so, so and so. So this is the content of the FIR, and this is a detailed FIR related to the first FIR. Little bit of short, my lord, just, but this is an FIR which covers everything. Also alleges there's a larger conspiracy involved in this case. So this is a second FIR. And this FIR also is filed by the circle officer and the executive magistrate, Patharkandi Revenue Circle, where the incident took place, the cause of action arises, madam. So it covers all the students, the 214 numbers of students, their involvement in this particular FIR, my lord. Now, we have challenged this FIR, my lord, and the bail was granted. My lord, before that bail, my lord, lordship can see the affidavit filed in this case by the state, that lordship will find page 59, 52, and 59.
One by the Home Political Department, one by the IM.
This is very important, that 52 and the 59.
These affidavits are filed by the state.
Affidavit filed by the state in that second case during the hearing of the bail petition, my lord.
The 58 only.
52, my lord. The first affidavit submitted by the additional secretary to the government of Assam Home and Political Department, my lord. The first affidavit in bail application so and so. In the paragraph 1, 2, and 3, my lord, basically the allegation in the FIR itself. For also the same FIR contents of the FIR. Now 5 onwards, my lord, important. That the accused person, namely the Mahbubul Haq, the Chancellor of USTM, Numan Ahmed so and so, so and so, so and so, were arrested in connection with the Patharkandi PS case number 54, my lord. That is the first case, my lord. 54 is the first case, my lord. And were subsequently shown arrest in the case number 55. This is the. Based on the substantial material evidence indicating their involvement in the commission of the alleged offences, it is pertinent to note that the Patharkandi PS case number 54 of 2025 was registered on 21/2/2025 at 10 p.m. and the GD entry was also made in so and so at the time, same date, and uploaded in the crime and criminal tracking network system so and so at 47 IST. To clarity, Patharkandi PS case number 55 was also registered on 22/2/25 at 10:30 a.m. and subsequently uploaded at so and so time. The difference between the time registration of the time uploaded in CNC is solely due to the server-related procedure. The custodial interrogation of the accused person is essential to trace the financial transaction and linked with the collection of the illegal payments from the students, recover crucial records and digital evidence till their possession, and that their association investigate alleged nexus between the accused and the CBSE officials concerning the allocation of the examination centers, and the record further statement of the students who has disclosed incriminating details about the promise made by the accused in facilitating unfair means. That the accused person was highly influential individual with substantial political institution backing, making them threat to the integrity of the investigation. It has come to the light that the certain political figure and the high-profile individual have visited the accused person while he is in custody, raising concern of potential witness tampering. That the statements of aggrieved students recorded so and so have provided damning evidence about their formal statements so and so. That the accused person have not cooperated with the investigation, has already deliberately evaded key questions during the police interrogation. That the premature release of the accused person on bail would severely prejudice the ongoing investigation, would like to lead the tampering of digital and financial evidence, including the online transaction and electronic communication, intimidation of the witnesses, complainants, particularly students who have testified against the accused, and the destruction of official record relating to the fraudulent admission and examination malpractices. Now, paragraph 11 is not important. That the counsel of the petitioner has relied on the judgment of Dhanraj Ashwini so reported in, however, the said judgment. So, in this case, what happened, my lord? It was a case of a shown arrest, my lord. So, we raised a question that in the case of shown arrest also, that the 47 and the 48 also needs to be complied with. There is no leeway to bypass the 47 and 50. Earlier 50, my lord. So that was our primary ground, because in that the second case, the no grounds of arrest was communicated to me. And 48, 47, they have even bypassed, because the contention of the state was that in a shown arrest case, it is not required. But the Supreme Court, we have relied on the judgment of the Supreme Court. So DC can basically, Lordship will find in this case, apart from the first case, that is the 54, there is no mention about any other case at that relevant point of time when it was filed. And this is date is, Lordship can see the date of this affidavit is 7/3. Page 58, 7th day of March 25, my lord, page 58. There is a one more affidavit, my lord, the next page, 59. This is by the IO of that particular case, my lord. In this case also, my lord, he has elaborately discussed about the materials, but the objection and the merits in both the affidavits are same. But in the second affidavit by the IO also, apart from the first case, there is no whisper about any pendency of any case against the petitioner, madam. This is also on the same day, the affidavit was shown on, that is on 7th of March 2025, madam. Then the bail was granted to me in this case, that Lordship will find order of the second,
41.
that is page 41, my lord. So accordingly, bail was granted to me. In the meantime, there are some more FIRs has been initiated against this petitioner, my lord. That is one at, my lord, Guhaigaon PS case number 31, that is in page 75. Then the one at the Kokrajhar PS case number 61, that is page in 81. Then one is Borpeta PS 72, that is also page in 87. All these three FIRs in these cases, my lord, this Honorable High Court given interim relief with a direction that no coercive action shall be taken against the petitioner, my lord. All these and these are all similar kind of FIR, my lord. But the second, as I have already shown, that was the most elaborate FIR, my lord, the second FIR. And these are also, these three FIRs also filed by some of the fathers, some of the relatives of the students, some of these organization, but these are there's a direction by this Honorable High Court not to take any coercive action till end of this month, my lord. The next date is fixed on 28th of this month, my lord.
All these order are annexed.
All these order I have annexed, my lord, regarding the
No coercive action
no coercive action
in these three cases.
in these three cases, my lord. Now what happened, my lord? When I was already granted bail, then I have been again shown arrest in this particular case that has been registered at Thekia Juli, PS case number 55 of 2025, my lord. Now, the most stunning factor of this case is that this case was registered, that is on 24/2/2025, my lord.
Case was registered.
Case was registered 24/2/2025, and the affidavit they have shown in, that is on 7 March 2025. That is in the February, 11 March. And these are all FIRs registered in the month of February. So when this particular 2 FIR was filed before this honorable court, affidavit was filed, this particular case was already registered at the relevant particular police station at Dekwajili, my lord. But surprisingly, the authority, the state, or the IO in that particular case is absolutely silent regarding the existence of this particular FIR, which has been registered at Dekwajili at that relevant point of time. And that information was not given to the court, that there is a one more case has been registered against this petitioner and which is pending for investigation. That FIR was not, that information was not supplied to the court nor to the petitioner here. So this is an absolute violation of the mandatory provision of the Constitution of the India. Now, coming to next, now the Lordship kindly see the FIR in this case, my lord, at page 98. Page 98, Lordship kindly see the first information received at Patharkandi, Dhekiajuli, date is 24/2/2025. Mark the date, my lord. Date is 24/2/2025. As I said, that this is prior to the filing of the 2 affidavit before this honorable court. Then the number 5, point number 5, place of occurrence, direction distance, that is Dhekiajuli. Place of occurrence is Dhekiajuli. Now this, admittedly in the first FIR, in the second FIR also, that the whole place of occurrence, that the student's agitation, whatever may be, that is had happened with Patharkandi. And they were taken admissions, admittedly, also at USTM, it's Meghalaya, Rivoi district. No way
No,
connected.
they appeared exam from Patharkandi.
Patharkandi, at
But
Patharkandi.
they were the students of USTM.
USTM.
Achha, for their convenience, it was.
That is the allegation, my lord. So that these are the students of USTM, but without going with the regular classes, they are appearing examination in the Patharkandi. That is their allegation, basically. But whatever, my lord, what has had happened, my lord, whatever, let us assume it something had happened in you. Everything had happened in Patharkandi, admittedly. And or in the Rivoi district and USTM. Nothing, no cause of action at the Dhekiajuli, my lord. But instead of that, the case was registered in Dhekiajuli.
How? On the basis of the
FIR lost by the father now.
father.
One of the, that 214 students, regarding that the second FIR,
Yes.
out of that 214 students, one father has lost this FIR, that is, Lordship will page the relevant portion as page 100. How he is aggrieved, my lord. Myself, the Muqsed Ali, 60, so and so, Dhekiajuli, Sunitpur, is a farmer by the profession. My son, Sri Farid Ali, students of class 12, USTM's University Science and Technology, Meghalaya, and appearing in HS exam. He was also undergoing classes at USTM campus under aegis of Vision 50 project for the entrance in the medical and examination college, engineering colleges. I gave admission in my college at USTM with a dream of bright future of my son at the study center. That, sir, the USTM authority, by inducing my son and many of his colleagues, trafficked them and enrolled them in the CPS Central Public School at Patharkandi to appear in the HS final examination there. As per information received from some public, it is learned that the CPS Patharkandi and USTME both are under the same foundation and Educational Research and Development Foundation based on Guwahati. The USTM authority took the whole amount of 5 lakh in the name of coaching with the guaranteed admission of my son in the any need. Just before this ongoing final examination, my son paid 40,000 to the USTM authority. So whatever may be the allegation, this is the son has taken the admission at the USTM that is in Meghalaya, and he has appeared in the examination that is in the Patharkandi. So the whole cause of action apparently on the face of the record, either in the USTM at Meghalaya or in the Patharkandi, my lord. No cause of action, absolutely he is silent about any cause of action in the Punitpur district, my lord. Now this case has also been registered under 3184, 3185, 3363, BNSS read with 11.1 of the public examination, promotion, and unfair means. My lord, in this particular act, the requirement of that if there is an investigation pertaining to this particular special act, there is an procedure has been laid down and the officer has been specified who can investigate these offenses, that is 12. Section 12. The officer empowered to investigate, my lord. An officer not below the rank of the Deputy Superintendent of Police or the Assistant Commissioner of Police shall investigate any offences under this Act, my lord. Now, let us come to, my lord, our FIR. To investigate this FIR, it was entrustment was given to one Sub-Inspector, Deepak Talukdar. Inspector of Police, my lord. Deepak and sorry, my lord, the page 99, Lordship will find.
Deepak Das or
Deepak Talukdar, sorry. Deepak Talukdar, page 99, Lordship will find the last paragraph. Name of the IO, Deepak Talukdar, rank SI of the police. Deepak Das is the OC, my lord.
Okay.
Deepak Talukdar is the SI who has given the power to investigate this. But as far as the Act is concerned, my lord, only the DSP or Assistant Commissioner, they can only investigate the case, my lord. So apparently, when case was investigated, it was by the Sub-Inspector in this particular case, my lord, apparently. So in some of the cases, all cases, my lord, the same procedure was followed. So what High Court has observed, my lord, in this connection, my lord, there is some observation in some of the stay order while granting the stay order, page 92, my lord. They can change the investigating authority later on. That's not the issue, my lord. But they have to take the prior permission of the concerned court to change the IO, my lord. Internal communication, changing the IO will not do. That is the observation, page 92, my lord. Lordship kindly, and that was considered by the learned public prosecutor Assam very fairly also.
He submitted that the case was re-endorsed to
Yes.
SDPO subsequently.
Yes, but he has also admitted that without prior permission, my lord. Page 92, page 92, my lord. That is our contention, and he has considered to that fact, my lord. Page 92.
This is in connection with which case?
This is in connection with my lord, Borpeta PS case, my lord.
The second or third FI,
Third
subsequent
FIR,
FI.
Subsequent FIRs, all three subsequent FIR, my lord, that is one Gukhaigaon, one Kokrajhar in Borpeta, similar kind of FIR, and the similar orders in all three cases, while protecting the in the this page 93, Lordship can see the last paragraph. The proceeding paragraph also, Mr. Bora has submitted that the FIR was registered by an inspector of police and it was endorsed to sub-inspector of police. Accordingly, Mr. Bora, in section 12 of the Public so-and-so Act, has been prescribed in the officer not below the rank of the Deputy Superintendent of Police or the Assistant Commissioner of Police shall investigate the offence under the Act. Today, Mr. Fukan has submitted that case has been re-endorsed to the subdivisional police officer so-and-so to investigate. To that effect, Mr. Bora submitted that the change of the investigating officer should be intimated to the Eleka magistrate, and without intimation to the Eleka magistrate, investigating officer cannot be changed, and this is the law which Mr. Fukan also agreed. So the public prosecutor fairly agreed the proposition, my lord, that without the prior permission from the court, there cannot be change of any investigating officer. So, considering all these things, my lord, that these all three FIR, Gukhaigaon, Kokrajhar, and Borpeta, the same procedure was followed. So, this court has stayed the arrest of this petitioner, my lord, in these all three cases. But his arrest was obviously mandatory for some people. So, this is the sixth FIR before your lordship now. Now, in the sixth FIR also, as a lordship insta, that this was also endorsed to a sub-inspector, which is not permissible under the law, my lord. He cannot investigate this offence, my lord. But he has investigated, he has also gone and arrested. Now, subsequently, it was handed over to the DSP without the prior permission of the court, my lord. That is our contention that they have changed it subsequently because of these orders, my lord. Subsequently, they have changed it, but they did not took the permission, leave of this Eleka magistrate for the purpose of investigation. Now, also, lordship has seen that this FIR has been registered at Ekiajuli, and this is the sixth FIR, and I'll say this is, though it is a sixth FIR, it is a outcome of the first or second FIR itself. So basically, it's a second FIR, as per which we used to say. If there is one more FIR for the same cause of action, there cannot be the second FIR. That's the settled proposition of the law. And coincidentally, the second FIR lodged in this case, that is in the Patharkandi 55, this was elaborately, it has covered everything, madam. And in their affidavit also, they have elaborately everything. They have said that there is a larger conspiracy involved. The students needs to be interrogated. Everything they have elaborately said. So from that FIR itself, that the Patharkandi 55, everything is covered regarding this alleged offence, madam. Everything is covered. If everything is covered, whether these subsequent FIR,
Yes, obviously.
these subsequent FIR can be investigated at all. That is my first contention. That it cannot be the FIR. It can be only be in 161 statement in connection, maybe in connection with that Patharkandi 55, my lord. This FIR absolutely, my lord, non-est in the eye of law, because the content of the FIR is already covered
Yes.
by that FIR itself. And the investigating authority also, he is also not has the power. Now, before coming back to the legal proposition, my lord, there is one more development in this case, that is also very vital to decide this case. That is the one affidavit filed by the informant in this case when this petitioner was produced before the magistrate court, my lord, during the product. That is page 107, my lord. He appeared himself and he filed an affidavit to the court.
The father, I think.
Father,
The informant here.
the informant and the father of the
Concerned.
he has said, my lord, page 108, my lord. I am the informant of the so and so, so and so, so and so. That's on the basis of this coercion. Now, lordship can mark it. On the basis of the coercion, undue influence by police personnel and the other authorities resulting in some misconception, I lost the aforesaid FIR Dhekriajali PS case number 55 on 24/2/2025, wherein I have erroneously brought about the allegation against the Mahbubul Haq and other USTM Vision so-and-so project personnel, and also alleged that my son was trafficked and enrolled in the Central Public School, Patharkandi, amongst the other allegations as directed by the authorities. That I had lost the FIR under pressure and the undue influence, and now after understanding all the material facts thereby clearly, I hereby state that the Mahbubul Haq and the USTM Vision for the so-and-so Patharkandi, the person are not involved in any offense as alleged in the FIR. That after passing 10th board examination in the year 2023, my son, S.K. Farid Ali, was enrolled and appeared in the class 11-12 CBSE board examination from the Central Public School, Patharkandi, and I was aware of the same. Moreover, any payments which I have made were all not only levied fees for the Central Public School, Patharkandi, and the Vision 50 coaching program, and nothing apart from that. No guarantee was provided to me for my son for clearing NEET and providing better marks in HS examination. That I have now realized my unintentional error, as such, the hereby declare that the Mahbubul Haq so-and-so are in the no manner connected in the so-and-so Dhekriajali. That I intended to settle the matter expressed in the actual, considering the mistake on so-and-so FIR against the accused person. In view of that FIR was lodged as a result of so-and-so, I do not have any objection if the aforesaid case is terminated against the so-and-so or others. I also no objection if the Mahbubul Haq as other persons is granted bail in connection with the intense case so-and-so. So this is the FIR file. The first line, the affidavit of concern, on the basis of coercion and undue influence, this man was forced to file this FIR. He is absolutely, my lord, illiterate man, my lord. His signature appears to be, my lord, and the FIR was lodged in English. So next one is the order of the magistrate, my lord, first day order. 113, my lord. He has discussed everything, my lord, but the case was later on fixed for another date. And subsequently bail was rejected. Bail was primarily rejected by the magistrate, my lord, only on the ground that is the early stage of investigation. That is the only ground. Though in the entire order sheet, lordship will find the whatever ground we have taken before your lordship, everything was also argued before the court, but it was not considered, neither was distinguished, simply because of the fact that Mahbubul Haq is an influential person and the early stage of investigation, whereas, my lord, our High Court in all cases, all previous cases, he was granted bail. 2 cases, he is granted bail. In 3 cases, his arrest was stayed. And the first case also, bail was granted. So, and the second case, affidavit also, he has not considered, madam, the learned trial court. His contention is that he cannot compound the offense. It is a non-compoundable offense. We are not on the compounding here, madam. We are only on the how this FIR has been initiated. The informant himself was influenced rather by the police authority concerned. And Lordship can see this is the 6th FIR on the same facts. One after another FIR is going out in the all over the state, madam. And Lordship can understand though I have been cited as an influential person, but who can be influential in this case?
11-3 I was granted bail. I would have been a free man. 11-3 only I was.
So, on 11-3, I was granted bail
Second case.
in the second case by the Honorable Court. On the same day, on 11-3, I was again picked up, shown arrest in this particular case, which was not earlier disclosed by the state that this was pending. So that point is enough to settle, apart from the second FIR. So coming back to the legal issues involved, now, if the information regarding the pendency of any case during the bail hearing is not communicated to the court, what is the effect? That is in the Supreme Court says, if that is be so, this man should be considered as free man. That is the language of this court, the Supreme Court, as well as our High Court by the Justice, Honorable Justice Ujjal Vair's judgment, my lord. And probably your lordship also dealt with the one matter in the particular case, my lord, the similar situation. So first, my lord, before going to the Uday Chand, my lord, this is a very short paragraph, my lord. In the Uday Chand, my lord, paragraph 5. In the Uday Chand case.
Yes.
Paragraph 5. Mr. Sketcher stated before us that the petitioner were enlarged on bail in pursuance of the order passed by the court on March 2, 1981, but they were subsequently arrested for some other offences alleged to have been committed by them prior to March 2, 1981. We are quite amazed at this statement that we should have expected that if after order of the bail passed by us, the authorities of the state considered it fit to arrest any of the petitioners for any other offences, it was their bounden duty to apprise this court before taking this person in custody, especially when no disclosure was made to us when we passed the order of bail that any case or cases were under the investigation against any of the petitioner. We regret that this elementary courtesy to this court was not shown, madam. Lordship, kindly mark the words, madam, because we are here for the establishment of the rule of law, madam. We would like to reiterate that the petitioner shall be treated as free citizen, madam. How the court has, that is in, my lord, 1983, and now we are still in 1924. Still, we have to follow the same agony from 83 to 24, my lord. Still, they are doing the same thing. Without informing, person is arrested, re-arrested, shown arrested, not informing the court. How many years, my lord, has been passed? So many water has flown down the river, but we are incorrigible, my lord. Now the Kamal Datta, this court has observed.
This was passed in 2016. Justice Ujjwal Bhuyan's order.
Yes, yes, 2016, my lord. Reported 2016, 1 GLT, GLR, passed in 5/11/2015.
Oh, sorry, 511 now.
The page number, lordship will find, page 543. The Plesitam G. The similar situation in this case also. The secondly, when this court, has your lordship got it, the
Yes.
Plesitam G? Secondly, when this court has granted bail in Pasigat PS case in 56/14, this court was not informed that the accused was also wanted in Basar PS case 9/14 and Itanagar PS case /304/13. Even the learned judicial magistrate first class Pasigat, who has passed the consequential order 1912/2014 following the bail order of this court, was not informed that the Tapan Datta was wanted in those cases where he is an accused. Not even the High Court, not even to the magistrate court also, my lord. Here also similar situation, my lord. I was granted by the lower court when the bail was granted. It was not also placed. It was stated in affidavit that Tapan Datta was arrested by Pasighat police on requisition of the Basar police from outside of the court on 19/11/14 at about 4 p.m. He was handed over to Basar police station on 20/11/14, whose turn produced in the accused before the magistrate on 21/11/14, which again beyond 24 hours arrest and so and so, arresting the accused in a different cases from the outside the court where he was granted bail without disclosing the court about the need to arrest him in another case is wholly unacceptable. When, my lord, this case was hearing was going on in the item the 55, my lord, they filed the affidavit, two affidavit, not only one, and that by the home. And they were absolutely silent that the one more case is pending. And they took a 7 days time to file this affidavit. From the first date when the hearing took place, they took 7 days time to file the affidavit. Even then, the case was long before it. That was registered in 24 itself. And the affidavit filed in 7th of March. Case was filed in 24th of the February. They were absolutely silent regarding the pendency of this particular case, my lord. Why? Just they're waiting that the moment I'll got the bail in one case, they will arrest me in the another case. So they are waiting for that so that I can be deprived of taking the legal recourses, my lord. I could have come before this honorable for anticipatory bail or no coercive measures in that case also. So they have suppressed it intentionally. Not to me, even to the court also, my lord. That's the very biggest, my lord, concern for us, my lord. How they can do it, my lord? The only purpose to defeat the justice, my lord. They're playing with the justice, judicial whole system, my lord. Apparently. What prompted? Why they have not filed in the affidavit that the one more case is pending? If I am so much, they can write everything about me, my lord. I am a habitual offender, they are saying. I am doing the conspiracy. But they are not disclosing. And they are, in this case also, they have registered what, my lord? The case under Special Act.
But this case is also from the that 214 who were appeared, and the allegation was there for unfair means or whatever. Same set of this FIR. His son was also appearing in that exam.
That exam, same. Because only 214 exams. He is out of that, one of them. Same exam, same students, already case has been registered. Now this is a second case on the same fact. There cannot be a second FIR for the same case, my lord. The TT Antony's case is. And this is the second FIR is an elaborate FIR. They themselves say that this is everything has been covered in the second FIR, my lord. They cannot say that there's more, something is more yet to come, my lord. They have elaborately everything has been disclosed in the second FIR itself. There cannot be the third one, my lord. FIR for the same cause of action. If we take it as a third one, my lord, where I have been arrested, my lord. All 214 students is covered in this particular case. And then now only the individual has come, only one individual. Tomorrow one more, maybe more. Now, in this case, my lord, so relying on the Uday Chand's case, my lord, the paragraph in the Uday Chand's versus so and so, the apex court has deprecated the practice of withholding the information from the court about the requirement of the arrest of the accused in other cases. It was held that if after order of bail is passed by the court and the authorities of the state is considered to fit the arrest fit to arrest a released person for any other offences, it was their abundant duty to apprise the court before taking such person in custody. In that fact, that the arrest were held to be contrary to the bail order passed by the apex court, and accordingly petitioner of this case were released from the custody, treating him to be a free citizen. Having regard to the above, the court is of the view that the accused Tapan Das should now be released, as his continued to detention has become clearly untenable. As noticed above, he has been granted bail by this court in 1 out of 4 cases, that is Pasigat PS case number 56 of 2014. He shall now be released on bail in connection with the other 3 cases, namely Itanagar PS case number so-and-so, Basar PS case number so-and-so, Alo PS number so-and-so, subject to the condition that he shall cooperate with the investigation of the cases and that he shall also appear before this court on the next date. Since the finding has been recorded that is so-and-so, so-and-so. Accordingly, the last line of this paragraph, my lord, accordingly, Sri Tapan Datta can now walk out of this court as a free man. This is the language, my lord. And the next part is regarding the 50,000 has been granted to this Tapan Datta because of his illegal detention in the subsequent cases. That was dealt in the second part. But the first part, so the ratio of these cases is very clear, my lord, that if you want to rearrest me, you have to inform the court during the hearing of the bail application also on the previous time. So that information should come to the court, my lord. Here, this information was never given to the High Court. Even then, he was subsequently arrested, my lord. So, this is teaching. Babu, why to do that? Puntu paragraph important. The main paragraph in this case is regarding the second FIR, 14, 16, 20, 21, 32, and 47, my lord.
Yes, let's repeat again. 14.
14, 16,
Yes.
22, 20, 21, 32, and 47, my lord. So, these are the ratio, but the 47, Lordship kindly, I'm reading 47. What was the observation made by the apex court when there is a second or the third FIR comes into for the same cause of action? It is further clarified that those persons who were arrested in connection with the CR case number so-and-so would not stand arrested in connection with the CR case number 154 of 2008. So there is a clear direction. They cannot be arrested in the second FIR. So the subsequent arrest, as per the Supreme Court, is in the second FIR is illegal, my lord. They cannot be re-arrested in the subsequent same cause of action, my lord. FIR for the subsequent one, same cause of action. They cannot be. That is the ratio of this case, my lord. Para 9 and 10, your lordship, own judgment, my lord. I'm relying on that also. So basically, that case, the lordship has relied on the Uday Chand's case, my lord, in this particular
Yes.
order, my lord. So apart from Uday Chand, my lord, our own High Court has elaborately discussed in Kamal Datta's case by the Justice Ujjwal Priya, my lord, that he should be treated as free man. My case also similarly situated, my lord. So I pray, my lord, at death stage itself, considering on the prima facie record, he should be released on bail today itself by your lordship, my lord. Without any, because any detention will be an illegal detention further, my lord. Any detention further, my lord.
Concerning one's information.
And this case is concerned, my lord, and lordship has seen already that informant himself filed an affidavit that under coercion and threat, he was forced to lodge the FIR.
Can we give- Yes.
Can be considered.
আমরা তাকে বলবো। আমরা start করে দেখাটা। President.
So I'm not on the ground of, my lord, the withdrawal of the cases at this stage, my lord, regarding his, but for the purpose of bail, it has to be considered because the recent judgment, the lordship knows that every informant has the right, participatory right in a proceeding, even in the bail at every stage, my lord. So that right has been given to the informant also. And when a right has been given, that right has to be also has to be executed, my lord. Not it's just in formality. It may be either for in favor or maybe in against, but it has to be addressed, my lord. In the Jagjit Singh recent judgment, my lord, the 24.2, the Ranit Supreme Court says that he has got a participatory right.
Yes, that is.
And if there is a participatory right, if the right is granted to a person, its right has to be executed, my lord. It cannot be just in formality. Court must give a value to that particular right, why this right has been granted. And this case, the informant, he has come of his own, filed an affidavit that under threat and coercion, he was forced by the police to lodge the authority. And lordship can see that the reason for all these FIRs, my lord, one after another in various places. What was the need for so many FIRs? Just to put me behind the bar? That to a chancellor of an university, my lord? And he is also suffering from, I have given all the medical document also annexed. So what was the requirement and why they did not disclose it, my lord? Why they have concealed the vital fact that one more case is pending? It is apparent that when the bail will be granted by this honorable court, and that has exactly same thing had happened, because on the same day when the bail was granted by this court, the same day he was taken to custody by the another police, my lord. They were waiting there just for the bail order. The moment the bail order was passed on that day itself, not in the previous day also, or in the prior few days, because case was registered long before in 24. They could have arrested me in the 24, 25. I was in the custody in the Koringal. Everybody knows about it, that I was in custody. But they have waited for the passing of the bail order, or they might have also probably পঞ্জিকা চাই আহা বুলি কয় স্যার পঞ্জিকা চাই পেলাই গৈছিল this is the right moment for the arrest of this particular person my lord.
It will help in the investigation.
Yes,
The right.
yes. So they might have waiting for that right moment. So this is my case, my lord, basically. So I pray, my lord, this is absolutely illegal detention of this man, my lord. Apart from the legal flaws, apart from that, my lord, that he's already considerable time he's in the custody from the already a month has passed from the first arrest, my lord. He was arrested in the first case 22 in 22 itself, my lord. And this case also he's in custody 9 days, this case. So his further detention is absolutely not necessary. Apart from my lord, the considering all aspect, the legal aspect, the investigating officer, he doesn't have the power to investigate without the prior permission of the court. This is absolutely an FIR which is subsequent to the already existing FIR, second FIR which is non-est in the eye of law. Then the non-informing the court, which is the biggest flaw in this case, that they should have complied it, and the non-compliance, it should come. This I should be treated as a free citizen of India as per as the Supreme Court and our High Court says, madam. He should be treated as non. In that case, he is not even not even allowed to go in bail. He is directly, he will say that he is a free citizen. He can go from the court itself.
Yes.
And the finally informant himself has come before. And Lordship knows what will be the fate tomorrow regarding investigation in this case. Nothing.
Thus, I'll hear to you just for 5 minutes. Actually, for Brown doctor's advice, I'm just taking 5 minutes. Okay, just 5 minutes. I'll appear for informant.
Let his submission be made, madam.
You're going to submit.
No, I've already filed it.
You have already filed your?
I've already
No,
filed.
Makaratama is there. Is there any other? You are going to submit verbally only?
Yes, madam.
Okay.
And one of the good things about appearing in this kind of cases is one gets to learn a lot of law on these issues, my lord. So these were issues that, my lord, this comes up regularly, my lord. But in this case, the informant, my lord, is a farmer. Is a farmer, my lord, and his son was admitted in this Central Public School of Pathakanti, my lord, where he had appeared for the examination. So, my lord, because of some misconception of fact, because when this entire investigation unraveled, my lord, a lot of people came to a lot of other students also, including the the informant, my lord. Because of this surrounding, the entire surrounding confusion which came up because of this case, my lord, some misconceptions of facts happened, my lord, which led the informant to lodge this FIR, my lord. But the informant, my lord, has no objection if the petitioner is granted bail. So, my lord, I'm not opposing the bail application. There's a legal issues your lordship will examine, my lord. As far as I am concerned, my lord, I am not.
What you want to say in regards to your, I mean, undue pressure was there on you. You have filed in one affidavit also.
I stand by my affidavit, my lord. This is an affidavit sworn before a notary, my lord. And this has been sworn on 13/3, my lord. And this was produced before the learned magistrate also when the bail application was moved. So I stand by the contents of the affidavit, my lord. And I don't oppose the bail application.
Yes. Okay.
Wait, visual lordship. First I beg to meet the contention made by the petitioner in respect of the investigating officer, power of investigating officer. Well, I beg to draw your lordship's attention to page 100, that is the FIR of this case, my lord. 100.
Yes.
Your lordship may kindly see the endorsement that one Deepak Talukdar, sub-inspector, has been endorsed. And this endorsement was made on 24/2/25 itself, on the same day on which the case was registered. Obviously, this is an administrative order for the purpose of endorsing the case to a particular investigating officer. Yes, I understand. Per law, this is wrong. Now, that mistake is administrative orders, you also know, but it is always curable. And there, and from the order itself, you also may kindly come. The order referred to by my learned friend, case 93. Yes, it cannot be changed without informing the Elaka magistrate only. That means procedure has been prescribed for such change of the investigating officer. It is not that there is absolute bar. There is absolute bar that once case is endorsed, it cannot be changed. IO cannot be changed. Now, I do not know whether thereafter any change has been made or not. And the petition itself is also silent. Whether any, without magistrate's order, this IO has been changed or not. So, my lord, now I beg to draw your lordship's attention. My lord, may kindly come to paragraph, my lord, page 108. Actually, this starts from page 107. This is the, my lord, affidavit filed by the informant. Your lordship may kindly see para 3. That on the basis of coercion, undue influence by police personnel, who is that police personnel is not revealed, and other authorities, who is that authority, not revealed, resulting in some misconceptions, I lodged the aforesaid FIR. See the nexus between informant and petitioner. That is why, my lord, that is why the result of case diary, relevant case diary is necessary in this case. But you also have seen the situation. The informant very first they comes and say, I do not oppose. This today it is first thing, lord. It has been listed for motion. And on the motion itself, the informant engages a lawyer to intimate the court that he has no objection if bail is granted. After coming out from bail, on bail, my lord, your lordship will see what will happen to the case. Now he is in jail, and from jail itself, he could influence the informant. Entire case will go.
He is in your custody.
Entire case will go, my lord, if he is released on the bail today. That is why, my lord, let the case diary come. I will produce the case diary. A short, since he is behind the bar, since he is behind bar, let a short date be given. I will produce the case diary, and on factual aspects, only after producing the case diary, I will be able to meet his, my lord, my learned friend's submissions. Without taking instruction from the IO or, my lord, factual aspect of the, without going through the case diary, my lord, I may not be able to make my correct submissions, my lord. That is why I need some time. Let the case diary come. A short date may be given, my lord.
May I just respond one? My learned what my learned has pointed out why they drag me into this, why make these imputations against me? I am a farmer by profession. I also do not want to divulge a lot of facts. In this case, and he has said that I have come on the first day. I have not come on the first day. This is an affidavit which was sworn on 13/3, and this affidavit was sworn produced before the magistrate, my lord. So I am quite aware of the fact. In fact, my televised interview is also there on record, my lord, where I have also stated that how this affair was brought by. So it's not a question of me lodging the FIR, coming here on the very first day. On 13/3 itself, affidavit was sworn. I went before the magistrate. I was quite aware of the fact that a person has been arrested. He is in jail. knowing that a bail application has been filed, so that is why he has come here. No need to, my lord, point fingers showing that there is some unholy nexus between me and the petitioner. My lord. Petitioner is doing their custody, my lord.
That's a right statement, my lord. If somebody pressurized him, it was his duty to reveal the name of the police officer who has threatened him. And an FIR should have been lodged against that police officer. How a police officer can misuse his office, misuse his power to, my lord, lodge an FIR, to threaten a person, a citizen, bona fide citizen, my lord, to lodge an FIR against somebody? And what interest has he got? What interest has that police officer got?
I'm just replying to what my learned friend is saying, not the first day, my lord. And this had happened, they are already submitted, my lord. When this whole thing unraveled, my lord, was this whole, the person was arrested, my lord. And most of the, at least I know, many of the students and their guardians were approached. So I was also asked that whether my son was studying in this school or not. I was with my son was studying there. He had also applied, he had also undergone that coaching, my lord. In this manner, my lord, this FIR was lodged, my lord. And I have also fairly admitted that there was some misconception on my part. Now, because of my misconception, some person is in jail. So I have come forward and I have said that I am not opposing. Merit of the case, my lord, my learned senior friend has submitted, the learned PP will submit on the merit of the case. I cannot submit on the merit of the case. I am only submitting that I have no objection because I do not want that because of my misconception. Some person. That is my
My only reply that this is an unholy, my lord, nexus, because the first day informants directly came before your lordship on the motion stage. But in some cases, what we can see, in some cases, on the first day itself, we can see the informant comes and objects. Then there is no objection from the public prosecutor that why he has come in the first day, how he come, how he is informed. There is no objection. Because in this case, because he has not objected to my bail, so this is an unholy nexus. But when the informant comes for an objection, there is no unholy nexus between the public prosecutor and that informant, my lord. Only when he comes for the no objection, then it is an unholy nexus between the petitioner and the informant.
The right is of participation.
But the right is the participation, my lord. How they can stop the participation? The Supreme Court in the judgment said from the every stage, in the first stage, is there any definition that he can't come in the first stage, cannot oppose and cannot argue or cannot support? To bail to appeal every stage, every day, he has the participatory right. That is the mandate of the Supreme Court. And he has said just because he has appeared in the first stage, it is an unholy nexus between me and him. Where from he is gathered? This is his presumption. But when the informant appears in the first day opposing the bail application, I have never seen these people are objecting that why he has come. Whether we have objected that this is an unholy nexus between the public prosecutor and the informant? Never. We have never objected such kind of things, my lord. Because we know our limitations, my lord. We cannot presume things just because somebody has come for objection. We cannot presume that there is a nexus between the public prosecutor has intimated somebody to object the bail application. Cannot be, my lord. We never did that kind of submission, my lord. And the custody, my lord, he was there. And apart from that, he said that is there necessity to, in the affidavit, he can lodge the FIR, it is up to him. I cannot pressurize. This is his affidavit before the court, in the learned magistrate court, my lord. He has not, and in that case, my lord, this man publicly, in the public domain, in the newspaper, everywhere, he has categorically stated that he has been pressurized by the police. We have the video footage that he has been pressurized by the police everywhere, but nobody has taken the cognizance of this statement, not even the state. Why the state is silent that some police machinery is doing undue? It is the duty of the state. They are monitoring every aspect, every statement. Otherwise, if I make any statement, anything against, I'll be picked up. আজিকালি কিবা কলেজ আর টিভিত ওলালে এৰেষ্ট হৈ যায় কিন্তু ইয়াত ইমানখিনি against the public servant he has made an allegation in the public forum there's no FIR by the state and he said why I have not lost the FIR to a rustic man He's a farmer. I salute his courage, my lord. In spite of the fact that he was threatened by the police officer, still he had the courage to come before this. And he is saying that the case diary is required, but the case diary is required only for the factual aspect, my lord. What about the legal aspect, the other aspect? Forget about the informants, my lord. Whether he comes before your lordship or not. But what about the illegal detention regarding the non-informing of that particular aspect? What about that submission, my lord? He has not addressed to that fact, my lord. He has simply said that just because of the informant has come, there's a holy nexus, they should not be granted bail. But what about the other legal aspect? Is it not a second FIR, my lord? When the first FIR is pending, is that the information was concealed to your lordship, my lord? When the bail was granted in the second FIR, there's 2 affidavits pending. Is there any whisper about the pendency of this particular case? Why there is no mention about this particular case? This case is pending from 2014 itself. Why not whisper not by the, I can understand the IO may not have the knowledge, but these affidavits were shown by who? That the Home and Political Department, my lord. They are silent about this aspect, my lord. And they are looking after the entire state, my lord. This is the parent department, and they are silent, considering the fact, so that they can arrest me again the moment I have granted bail. And that is what has exactly had happened in this case. The moment I was granted bail, on the same day as I was picked up, he was waiting for 24 to 7, waiting for my arrest, my lord. So even then I can pray for the interim even bail. I'm not objecting to case diary in that case. If you want to go to it, but in that case, lordship kindly consider, as per this judgment of the Honors Gusai, my lord, interim should be granted, my lord, here itself, because every day's detention, my lord, today itself, if tomorrow nothing comes up, my every day detention will be an illegal detention. And this is the travesty of the justice, my lord. Nothing more than that, my lord. This is absolutely, my lord, lordship can see one after another FIR is going on against me, my lord. And the court has stayed the proceeding against me. Court has granted bail in all other cases, 2 cases, my lord, considering every aspect of this case, my lord. Then why my detention is necessary in this case, my lord? What purpose, my lord? Just to satisfy somebody, my lord?
One thing, my lord, so far ratio is concerned, my lord, your lordships know, ratios are in criminal jurisprudence, ratios are applied according to the facts and circumstances of the case. So far this case is concerned, my lord, so far allegations in the affair is concerned, my lord, so it is so serious, my lord, education has been converted into a commodity, my lord, which is the backbone of the, my lord, society, education. This has been turned into a, my lord,
for that there are 6 FIRs necessary, my lord.
Yes.
When there is a
No,
second FIR
Yes,
itself,
Yes,
is
I
elaborated.
understand law relating to second affair. Apex court has said.
We are
in
not
a
here for
catena of
the
judgment,
political lecture, my lord.
In a
I want to
catena
address,
in
my
a
lord,
catena of judgment,
let him-
Apex court has said
let him
what is to be
object
done
to this.
in respect of second
Let him
affair.
submit
It-
regarding the
it does not
non-compliance
mean
of the
that second
information.
affair has to be thrown outright to the dustbin. my lord.
No, no.
It is to be used as, my lord,
160 or said, that
Yes.
is what my submission also.
This is the preliminary stage of investigation.
No,
Why,
my lord.
why
Yes.
without producing the case diary, he should be released on bail?
No, regarding what about this, my lord? What about the which is not informed? This is on record, my lord. Why the court was concealed? That vital information. What about that, my lord? Let them submit on that. We are not only
Yes,
political lecture.
These are all matter of facts.
This
Whether
is on
informed or
record, my
not.
lord. This is-
Whether informed
this
or
is-
not, these are matter of facts.
No, my lord. This is a
That-
matter of
whether
record.
in
How can
respect
it be
of-
a matter of fact, my lord?
Whether in
Information.
respect of
This is
this
an affidavit.
FIR,
This is an affidavit shown by the political additional secretary, and he has said this is a matter of fact.
yes.
I am surprised, my lord. I'm flabbergasted. This can be a submission on an APP that this is a matter of fact. This is a matter of record, my lord. Absolutely they are silent about the fact. And this is what the Supreme Court says, that you cannot conceal when the bail application is pending. You are not supposed to. You are bound to. The wordings are very serious in that judgment, my lord, in both the judgment. You cannot conceal. This is what exactly has happened in this case. They have concealed the fact. Then why the concealment? So that they can arrest me, so that I cannot take the advantage, legal recourse. I cannot come for the stay, or I cannot come for the anticipatory bail. That is the intention. That intention is apparent on the face of the record. And he's saying this is a fact. The affidavit can be a fact. I have heard it for the first time in my life that in affidavit in order.
managing
I have.
You
I am
may
saying
hear
about my,
for the first
Mr.
time.
Das, I am saying about my
Affidavit is
I am not
sworn in
saying
only
anything.
in respect
You-
of facts, my lord.
My lord, I am
Nothing
saying
else.
affidavit, no, sometimes affidavit is also fact, also knowledge. Also a matter of records also. If you have gone through the affidavit in any type, if you have drafted an affidavit, you'll see that sometimes it's a knowledge, sometimes on record. There are two parts. So this is what? This is the affidavit filed by them. There's no, I'm simply saying that you have filed the affidavit, there's no mention. Why can't you admit that proposition, my lord? Can't be brave and admit that. Let us prevail the rule of law. We are not for anybody, my lord. We are just for the rule of law. Why you are standing here? Our duty. We are also officers of the court, my lord. We have also duty to prevail the rule of law. This is the rule of law, my lord. This is the judgment of the Supreme Court. We have to honor it. You address on the judgment that no, this is not applicable in this case. No, this is the facts. This is I'm never surprised. This is the standard, my lord. Lordship, kindly grant me the bail, my lord, either interim, my lord. Because if not disposed today, my lord.
I have objection to interim bail.
Okay.
Any
I'll pass you.
sort that, my lord? Your lordship.
Pass
Police
you.
the case bail.
Obliged, my lord. Highly obliged.
Thank you.
Huh? I don't know, it may be completed today or not today, how can I know? If it is, I mean, putting here, dear, then, Monday, there is no objection. Just right. Okay, order will be released. If you don't make any entry regarding disposal or order, but order will be released. Yes. Item 11.
Your lordship, the 483 bail application, FR is page 10. Relevant portion is, my lord, page 14. May I read? Sir, with due respect, I have the honor to inform you that yesterday on so-and-so at so-and-so, information was received from police control room and that one vehicle bearing registration number so-and-so was loading beef at Hillview Holiday Home Resort under Gorsuk PS area. Accordingly, as per the order of OC, Gorsuk PS, I along with PS staff left for the PO after general diary entry was made by the officer in charge Gorsuk Police PS, Hyde Gorsuk PS case number so-and-so. Accordingly, I along with available on duty staff detained the suspect container vehicle Tata so-and-so yellow color bearing registration number so-and-so at Service Road NS 27 nearby Nizon Hotel after a deliberate siege. During inquiry, it could be learned that the driver of the vehicle, namely Bijon Singh, son of so-and-so, so-and-so district, so-and-so, and was smuggling it to Aizawl illegally without any valid document or permit. Hence, the vehicle along with the suspected beef later weighed and found 1300 kg suspected beef packed inside thermocol box was duly seized by White Gorshuk PS number so and so. It also suspected that beef was from stolen cattle slaughtered illegally, brutally. My lord, after lodging this FIR, I was arrested on 8/2/2023. Since then, I am behind the bar. Last 42 days. My lord, actually, my lord, I am not neither directly or indirectly buying or selling the beef, my lord. But already the alleged meat has been seized. Maybe my lord.
You are
at a
the
custodial
proprietor of
detention.
that hotel?
No, my lord,
chain?
I am the driver of the vehicle.
Driver?
Driver of the vehicle. So, my lord, alleged meat has been already recovered, my lord. Further custodial detention may not be required for the purpose of investigation. I have already 42 days behind the bar. This is my humble challenge.
You are the driver?
Yes,
Yes,
my lord.
driver of the vehicle.
Yes, what happened?
He is in the custody for last 41 days. He is the driver of the vehicle. That's it.
Mr. B. Buragohan,
Be there.
heard Mr. B. Buragohan, the learned counsel for the petitioner, and also heard Mr. B. Borthakur, the learned additional PP, appearing on behalf of state respondent. Back to this is an application section so and so, connection with so and so. It is submitted, Mr. Buragohan, that the accused petitioner is behind the bar since last 42 days. And he is no way involved in, and he is not an innocent, innocent, and he is no way involved in the innocent. However, he is in custody since last 42 days. He is neither the, he was also not aware about the packaging and packaging of the beef meat, which were loaded in his vehicle. And being a driver, he was just carrying the boxes in his vehicle. Further, he submitted that he is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next one. Mr. Borthakur, the learned additional PP, submitted in this regard that without going detail into the merits of the case, the length of detention may be considered. And DD1. Where it is pending cases?
Yes, CGM.
CGM, Kamrup Metro.
Kamrup Metro.
CGM, Kamrup Metro. Okay, it will be disposed.
Oblige.
You are granted with bail.
Oblige. Fine.
I think
Met please, Your Worship.
Yes.
To bail application, POSCO is there, Your Worship.
POXO is there.
Yes, Your Worship. Such as admit submitted, Your Worship.
Oh, charge sheet is cases, charge sheeted
Yes,
case.
Your Worship.
Acha.
First it submit one.
Question lifted for the order. Last case, sir. Please, Your Worship. Second one.
Search is yet to be placed.
Submit the update, but he submitted the CS.
Yes, search it submitted.
Charge sheet submitted. Otherwise, he got arrested on 4/2/2025. But within a very short period, most probably charge sheet is also submitted.
Page 20, my lord, it
Yes.
reflects, my lord,
20.
2-0. But in the petition, there is no mention about the search sheet. My lord.
So that is, so we don't know at this stage
The
whether
petitioner,
CS,
he has to file one additional affidavit by,
there is only one mention that completed and CS against the aforesaid so and so
there is no mention about the search.
already completed and he has submitted. But I don't know whether it has already been submitted or accepted by the special judge POXO. You just, huh? You do have such that information? No. So then what to do?
My lord, let her get the instruction, my lord, matter will be fixed from any other next week, any day.
Otherwise, let us call for the case, scan copy of the case record along with the case diary. If it is there, then we'll come. If it's not, then it is. You take steps for the issuing notice of the respond number 2 also. Yes, Botaku can be fixed because notice has to go again.
Yes, otherwise the number of the case search sheet is not there. Madam. Problem is that. No, let her file an additional affidavit by mentioning.
You file an additional affidavit here, mentioning the CS numbers, CS number, and if any other particulars are there. When it was filed, under which section, against whom this can be brought. A copy of the CS may be annexed. Because in your petition also, this no mention about this charge sheet and all. So, okay then. For her additional affidavit, when it can be fixed.
One short date, 27th of March.
Because 27,
27.
बहुत cases है ना. Fixed matters are 27, 28 loss maybe 26 or 25 कोई do rather maybe 25th. Let's see. Check. Tuesday it can be 25th. You just simply file the additional affidavit, will pass the order for filing an additional affidavit. In the meantime, can notice be issued? No, it will not be served the purpose.
Yes.
For filing additional affidavit. Simple order.
53.
50.
May please, your lordship, the petitioner are, two petitioners are, two are the brothers, lordship. The owner of the statement is false, lordship. The other,
Petitioners are the brother.
the lordship.
Then
The lordship in the ground of the arrest, lordship, the page 12, lordship, type of lordship. Lordship, the number one, the below noted arrested accused persons are co-accused of the case. The previous arrested accused person stated in their statement that below noted arrested accused persons are sold stolen scrap items to Lalsanali Dam. Petition number one. Situated at Kodavari. I am the owner, lordships. I have no theft any items, lordship. No recovery any. The other accused, the same name, Lalsanali was arrested, lordship, in this case. So the license is there, lordship, the page 17, lordship.
Okay, 14 is the forwarding report, third paragraph. During the course of inquiry.
page
Right.
14.
Page 14.
Type to question.
Page 14.
Brief fact of the case, third paragraph. During the course of inquiry.
Acha. It has come to the light. This is the position. Actually, the dam owner,
Yes, lordship.
they have associated with those thieves and all. So they used to receive those stolen items. That is the admitted position. Anyway, since when he is in custody?
28.
28th of February.
Today is 21 days.
21 days.
Okay, then when can be fixed?
The length of detention, lordship.
First of April.
First of April.
Before Eid, lordships. No material against me, lordship. The
Before it, in
Then
fact,
28,
27, lordship.
we don't have any
26.
dates. We don't have dates.
The lordship, the other PA number 7,
When it is fixed?
7 to
BA,
1, lordship. BA
BA?
7 to 1,
BA 7 to 1, 25.
25,
When it is fixed?
27.
27. Okay, 27 on look at fixed.
All for the case day.
BA along with BA 7 to 1 2025. Fix up 27 committee. Okay, we are fixing.
Diploma.
14. Four passing. Hit case on yes. Yes, Mr.
That should be, there's about 125 CRPC matter lodge.
Hmm.
The impugned order is at page, the last page of the petition lordship, 153. Parties are present, married lodge. The last page lodge,
123,
153 lodge, last page,
153, okay.
last page lodge.
Yes. Hmm. Yes,
It is the order of the principal judge one family court lordship.
Hmm.
11/2/2025. Parties are present, heard the parties on the prayer of interim maintenance. The petitioner has stated that she has no earning. Therefore, she wants interim monthly maintenance of rupees 30,000. According to her, the monthly maintenance of the opposite party is 2 lakhs, but she has not submitted any authentic document regarding the income of the opposite party. The petitioner has admitted that she is a graduate. In his written statement of assets and liabilities, the opposite party had admitted that he is the owner of a fair price shop and his monthly earning is rupees 5,000 only. The opposite party has admitted that the petitioner has no permanent earning source. The opposite party has not stated anywhere in his written statement that what is income source of earning of the petitioner. However, considering all the opposite party is directed to pay rupees 4,000 to the petitioner from the date of filing the interim maintenance petition. Petitioner is cross-examined, fixing 18/3/25 for evidence and cross of PWs. Opposite party may submit his written evidence. Lordship, here I have to first read out from the criteria for determining quantum of maintenance, that is from Rajneesh versus Neha Lordship. I'll read out because there are certain facts which I have, which will be based on this ratio Lordship.
but the assets and liabilities were already produced, I think, before the court.
Lordship.
From the order itself, it seems that assets and liabilities were produced at the time of the passing the order
Right.
of interim.
Lordship. What Rajneesh versus Neha mandates Lordship is that along with the assets and liabilities, two basic things Lordship. If any of the parties is as income to ITR assets Lordship, that has to be submitted. And at the same time, bank account for the last 3 years Lordship, that has to be submitted. Now, Rajneesh versus Neha mandates if that is the mandate for Rajneesh versus Neha Lordship, I have submitted my assets and liabilities, that is at page 62 Lordship. Page 62, my education qualification is high secondary pass. Then in the serial number 5, date of marriage is 16/9/21, date of separation April 2022. General monthly expenses of the applicant is 7,000. Then Lordship, my monthly income is at page 63 Lordship, 5,000. Now Lordship will turn to page number 128, the assets and liabilities of the respondent wife Lordship. Here, going to the assets and liabilities, that is at page 128 Lordship. I'm reading from page 129. Educational qualification of the husband wife BA pass Lordship. Then in serial number 7, she doesn't state about her monthly expenses. All the columns are, all the sentences are here. The blanks is remain blank Lordship. Then Lordship, reading from the page number 134 Lordship. That's serial number 9 Lordship. Page number 134. Furnish copies of bank statement of all accounts for last 3 years. She writes not applicable, applicable in her case. Now, Lordship, going by this,
what I can understand is, she doesn't have any bank account, so it is not applicable in her case. It's not applicable. Now I'll be reading out from page 51, Lordship. That is, on the same date that the order for interim maintenance has passed, she was cross-examined in the case, Lordship, as PW1. In my statement of assets and liabilities, I have not produced my bank statement. I have a bank in Allahabad Bank, Borkha branch. It is clear, the mandates of the Rajneesh versus Neha, Lordship, that the bank account statement has to be submitted. She admitted that this is the she has one bank statement, Lordship. Now, Lordship, I have also, during the cross-examination, I have also given suggestion that that she earns a good amount of money by stitching and embroidery, Lordship, and also that she, during cross-examination, she stated that, I'm reading out from page 151, Lordship. The opposite party never abused me physically. I lost the FIR as I was mentally tortured by the opposite party. This much is an allegation, Lordship. Now, Lordship will turn to page number 68, Lordship. That I have stated that my income is rupees 5,000 per month, Lordship. That is, I have a fair price shop. At page 68 and the continuing pages, Lordship will see my income, Lordship. The commission I earned in the month of July 2023. When I submitted the assets and liabilities before the court, Lordship, it is 4,969. That is the commission I have earned. And regarding my bank account, Lordship, the sale proceeds, Lordship, it comes to my bank account and then I submit it to the government, and then the commission part, Lordship. Now, in the continuing pages, I have submitted, Lordship, and the 4 pages, my earning from fair price is sometimes 5,000, sometimes 4,000. It is like that. My average income would be around 5,000, Lordship. But here, I would like to submit one judgment. I'm relying upon this judgment, Lordship, of this honorable court. Lordship, this case was decided on 7 to 2024 by Honorable Justice Robin Phukan, Lordship. Ratan Datta versus Sunita Datta. The relevant part is at paragraph 10 at page 3, Lordship. Yes, here in this case, having gone through the impugned order dated so and so, I find that the petitioner and also the respondent have not submitted their affidavits disclosing the assets and liabilities in the aforementioned proceedings before a learned court below, before deciding the issue of interim maintenance as mandated by the by the Supreme Court in paragraph so and so in the case of Rajneesh Supra, and also in the case of Aditi alias Mithi. Though the petitioner has sought time to file objection, the same was refused by the learned court below. That being so, the impugned order cannot be withstood the legal scrutiny, having been passed ignoring the law laid down by the Honorable Supreme Court. Then, paragraph 12, Lordship, the aforesaid exercise has to be carried out in a period
okay,
of.
then you are agree with the order of the interim.
Lordship.
It was passed on 4,000 rupees. But admittedly, your petitioner also admitted that the opposite party or the respondent has no income. Though she may be a graduate, but such kind of income was not there. So that's why interim was granted for tune of rupees 4,000. Obviously, these are the grounds that you have mentioned here. It will be decided at the time of final disposal of this case. It is the motion stage because we are not in our picture.
But
So, yes.
My submission is that
want
without
to
the
pray-
submission
you
of
want
the
any-
bank statement, Lordship, that this quantum is not, it cannot be decided, Lordship.
It will be, we're not going to finally dispose of this matter. It's a
Right.
motion stage. What I am asking you, that you would agree with the order of interim.
Lordship.
That is understood. The question is that supplying of the bank accounts and details, etc.
Lordship.
are there. Do you
Lordship.
want have any other prayer for interim? Because it's a case of 4,000 only. Do you have
My
any
earning
other?
is 5,000 lordship. How do I survive lordship? I have the only small fair price shop from where I have been earning lordship. It's 5,000 only on record lordship. I have submitted in the trial court bill. I submitted here. Out of 5,000, if 4,000 is awarded, how do I live my life lordship? It has to be accordingly the standard of the husband lordship. So my prayer, two prayers, lordship. The interim order is granted that may be stayed by this honorable court, and also that because the order as the interim order reflects, the next date is fixed for my submission of DW's lordship evidences I have to submit. But without submission of her, when she in her cost statement stated that she is having a Allahabad bank account lordship, without that, how can I take my defenses lordship? So entire proceeding has to be stayed in that case, lordship.
Entire
Because
proceeding we cannot state.
otherwise, lordship, what defenses I can take?
You can take your defense. You can apply for the bank statement. Now it is a computer generated all these things.
I
So you
cannot
can,
get my anyone's person's bank statement, lordship. If my wife has to submit it before the trial.
or
court.
you can just tell us that in the, I mean, here, at the time of her cross-examination, she took that, she replied that she has a bank account in the Allahabad bank account. So that plea you can take otherwise, but stay cannot be there.
My
As a whole, we cannot,
lordship,
obviously interim may be state, unstate, it is not state is a different part, but the entire proceeding cannot be. This is a 125 case, we cannot stay.
but entire the awarding amount of rupees 4,000 is illegal without submission of bank statement. When he herself submitted during cause examination.
That matter we'll see to it, but the
Lordship.
entire proceeding cannot be stayed. Or on the next day itself, if it is a come in admission column, that matter finally disposed of, or the other side agrees that yes, the bank statement was not there at the time of filing of the assets and liabilities. So matter may be it may be a case of remand for assessing the further
Fresh.
things and all fresh.
Assessing our price.
But at this stage, that's what I'm okay. Then we are passing the order.
Lordship.
Heard Mr. Andeka, the learned counsel for the petitioner. This is an application under section so and so in connection with so and so. Issue notice to the, is the only sole respondent or state is
Sole-
also from a part?
Sole respondent.
Issue notice to the sole respondent to register area and as usual process. And also call for the scanned copy of the LCM. However, considering the submission made by Mr. Deca regarding his annual income, regarding his monthly income, and also considering the sorry, statement made by him while submitting his assets and liabilities, along with the bank statements, etc. The order of the impugned order of interim maintenance dated operation of impugned order dated 11/2/2025 be stayed in next date of listing. It will be stayed.
Oh, let's go.
List after 4 weeks.
But by way of this petition, we are challenging the FIR for quashing, raising a preliminary issue that alleged offense is non-cognizable offense. So here is a statutory permission is necessary, which is not there. So on the last occasion, honorable court was pleased to call for the case record, case diary, and that was
Is there not received?
received. So case diary is necessary,
Why it is in motion column, in fact?
wrongly listed.
It can be listed in the admission column itself, I think. no?
Well,
Anyway, you have not received the case diary. Now it is still under stage of investigation.
sorry,
Still under stage of investigation or charge sheeted matter?
investigation.
Investigation.
Yeah, under investigation.
Heard Mr. K. Raman, the learned counsel for the petitioner. And also heard Mr. P. Potaku, so and so.
They have challenged one, Jimma order, initially regarding a pet dog, Initially that order, one order passed by the Your Lordship at page 43, order passed by the learned judicial magistrate, whereby granting the Jimma of the pet dog to the petitioner. And thereafter that, one criminal revision was filed by the petitioner before the session court. And ultimately, my lord, that order was kept in abeyance. And now in the same petition, they have also prayed for the Jimma of the, my lord, that challenging that order of the learned session court, and at the same time also, my lord, for quashing of
So
the.
by the instant petition, they are challenging 3 orders or what?
No, well, that part was not
Order of-
considered, that part was not considered by the honorable court. Court is only concerned with the FIR, my lord. And in that, at that regard, my case diary was called for. And we annexed that order when the materials may not be suppressed. That's why we annexed here.
Anyway, my lord, I will get the case, the matter may come up
Yes.
in the admission column.
Yes,
Why
well,
dog is also involved here?
my lord, matter
Cruelty.
relates to my lord, prevention of cruelty to animal act.
Acha,
And pet dog allegation.
pet dogs.
Yes, well, allegation that the owner of the pet dog beaten up the dog. So it's a case of offense under
Oh, that is the case, na?
Yes.
Acha, okay, okay.
No,
Why he was so cruel to his own dog?
no, that is allegation. No such evidence.
You are pet dog, why you're beating
No,
so
well, that is
mercilessly?
allegation, my lord.
Because it's a.
And the
this is
informant is the, my lord, he is running an NGO, my lord. He lost
Okay, okay, anyway, you are challenging that case
Yes,
only, okay. Also, in pursuant to order dated 5/3/2025, the case diary was called for, but it is submitted by Mr. Borthaku, the CD is not yet received. Issue reminder, let the matter be listed in admission column, yes, when it can be.
Short date.
Short,
10th of
short.
April, my lord.
10th of April, listing it on 10th.
10th.
Yes, obliged.
16.
মোৰ মানে কুকুৰক মাৰা বুলি ক'লে, okay, এইটো এটা ডাঙৰ কথা চলিছে, কুকুৰটোক মাৰি মাৰি understand কৰি দিছে।
This is application under 528 of the Bharat BNSS lordship for recalling the warrant of arrest issued against the petitioner by the import order 24/2/2025 lordship.
You're challenging the what?
So I can move it on.
FIR?
For
কি? কি ক'লে?
recalling the warrant of arrest lordship,
আচ্ছা, recalling of, আচ্ছা,
which is issued on 24/2/2025 lordship.
24?
2025 lordship. And XRE page 21.
Where your petitioner's name is?
Samir Puri.
Samir Puri.
Lordship, I have submitted petition lordship to engage counsel. Due to my
On that day, you filed a petition through
Yes,
your
yes.
engaged counsel.
Yes, lordship. And next are D page 19 lordship and 20 lordship. My medical petition lordship.
Annexure?
And next are D page 19 and 20 lordship. And medical petition lordship. Due to my illness, I am unable to present.
Oh, to get the delayed, sometimes one accused remain absent and on the other day, the other remain absent. So you're playing that tricks.
No,
Then the court observe in that way only. Suppose one day I'll be absent, on the next day you just remain absent so that it cannot be proceeded. That is the thing. Otherwise you were absent with stay.
No, no.
Your engaged counsel had already filed a petition on your behalf.
see, only last 2 days lordship.
Huh?
Last two occasions I have not appeared hosting for the due to my medical problem lordship.
So now see para number 8. The record further revealed that either one of the accused is absent on the date fixed or both of the accused remain absent on the date fixed. And due to this fact, charges framed on so-and-so and after till then completion of the evidence, so-and-so. So charges were framed, I think, on 19/4/2017. But till that, the evidence could not be completed due to your absence. Sometimes you remain absent, sometimes the other remain absent.
So next day fees on.
But the question is that if someone suppose
Yes.
remain absent also, if there is a question of identity, then the matter would be different.
Yes, ma'am.
Otherwise, in absence of the advocate also, if it duly represented by the council, the evidence can be recorded. That can be recorded otherwise.
And otherwise, my lord, as per new law, my lord, in his absence also, my lord, trial can proceed. My lord.
Yes, yes, can proceed.
One last chance may be allowed if on that date, my lord, he failed to appear before, and my lord, in all subsequent dates, he should appear before the trial court. My lord.
Is a sessions case.
Only for the
Yes, lord.
completion of the investigation. He is the owner of the printer. 489D case.
So you are absent only on 24/2. On
20
2 dates, will be in 2 dates.
2 days, Lordship. Actually, my medical problem, I have submitted my representation.
No, whatever, you remain absent through your counsel
Yes.
on 24/2 and other date when you were absent.
Page 22, my lord, second paragraph.
Yes.
On 8/1/25, the prayer of the accused Samir Puri was allowed. But today also accused Samir Puri is absent and not a single document of their illness. That is, the-
Acha, acha. Okay, that was the observation.
yes.
Heard Mr. J.J. Gogoi, the learned counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional PP, appearing on behalf of state respondent. This is an application, section so and so in connection with so and so. It is submitted by Mr. Gogoi that the present accused petitioner was regularly appearing before the learned trial court below. However, on 24/2/2025, he could not appear due to his illness, and on his behalf, his NBS counsel also filed an application, but the learned trial court below did not consider his application with a view that on last 2 occasions, that is on 8/1/2025 and 24/2/2025, the accused petitioner remained absent on the ground of his illness. However, the petitioner further he submitted that you did not file any medical document on before the court below.
Lordship, actually, I'm sent second half, Lordship, the medical patients. And here I want to submit, but already order passed. That is on my report.
He further submitted that he was supposed to file the medical documents, but as the learned counsel had received the medical documents on the second half, he could not produce before the court, and without any medical documents, the petition was filed, and that was rejected, issuing non-NPWA against him. However, the accused petitioner is ready and willing to appear before the learned session judge on each and every date to be fixed by the court if he is granted with the privilege of bail. Next paragraph, Mr. Botaku, the learned additional PP submitted in this regard that considering the absence of the accused petitioner in 2 occasions on the same ground, the learned session judge had rejected the prayer. And more so, the petition were also not supported with any medical documents. However, he submitted that one more chance may be given to the present petitioner to appear before the learned trial court below. Next paragraph, learned session judge below. Next paragraph, considering the submission made by learned counsel for both sides, I have also perused the case record and the imprint order dated 24/2/2025 passed by the learned session judge, Lakshmipur, not Lakshmipur. Full stop. It is seen that the learned session judge had made an observation that the present accused petitioner remained absent on 2 occasions, that is on 8/1/2025 and 24/2/2025 on the same ground of illness without supporting any medical documents. However, considering the entire aspects of the case, previous conduct of the accused petitioner, I find that one more chance may be given to the present accused petitioner to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. Against you, NBW has been issued.
Yes, Lordship.
When next date is fixed, can you tell us?
27/3/2025.
27/3. as submitted by the learned counsel for the petitioner, the next date is fixed on 27/3/2025, and accordingly, he is directed to appear before the learned session just so and so on or before 27/3/2025 with an appropriate application for regular bail, which may be considered in accordance with law and and till so and so NBWA issued against him will be state or suspended. Your NBW is state first. And you appear before the learned trial court bill on or before 27. Disposed of. Happy birthday. So you're for the petition?
Petition.
Side with petition with the consent of the other side, if for an adjournment. It will be listed after 2 weeks only. Not today.
Much of it.
List after 2 weeks.
17.
May I please, Your Lordship?
Yes.
Also, this is a petition under section 528 of BNS, paying for quashing of FIR, charge sheet and other consequent proceedings. First of all, Lordship, I would like to take my Lordship to page 22. 22, FIR Vanigular. May I read it? To the Superintendent of Police, South Salmana, Mankasar, Police District, Hatsimari. That is South Salmana, the so and so. Sir, সম্মান পূর্বক বিনীত নিবেদন এই যে যোৱা 5 বছৰ মানৰ পৰা নিম্ন বৰ্ণিত 1 নম্বৰ আসামী জনৰ লগত মোৰ ভালপোৱা সম্পৰ্ক চলি আছে আৰু উক্ত 5 বছৰত 1 নম্বৰ আসামী জনে মোক বিয়া কৰাৰ প্ৰলোভন দেখুৱাই বহুতো বাৰ বিভিন্ন স্থানত 1 নম্বৰ আসামীয়ে মোৰ লগত শাৰীৰিক সম্পৰ্ক কৰে 1 নম্বৰ আসামীক মই বিয়াৰ কথা কোৱাত 1 নম্বৰ আসামী জনে আজিকালি কৈ দিনক দিনে মোৰ লগত যৌন সম্পৰ্ক বহাল ৰাখিছিল যোৱা ইংৰাজী 25/8/2024 তাৰিখ সন্ধিয়া 5 মান বজাত মই 1 নম্বৰ আসামীৰ লগত বিয়াৰ উদ্দেশ্য
Just a second, it is a case of 376 also, nahi what?
Yes, yes. On the pretext of marrying her, my lord, established physical relationship. That is the allegation.
Oh,
This is can go.
Application under section 528 BNSS, my lord. The impugn affair has been assailed. Your lordship will find at page 12.
Where?
12. Annexure.
yes.
May I read your lordship? Most respectfully, I beg to state you that my married daughter, Dulumoni Kolita, is 30 years old, and her daughter, namely Pahi Kolita, is about 6 years old. The accused married my said daughter in the year 2010 and was living conjugal life. On 3/4/2024, at about 9 p.m., my daughter informed me over phone that the accused, after setting fire on her clothes, including her daughter's clothes, was seizing her to kill with crowbar. Hence, my son, Narayan Bhakkar, brought her to our home on 6/4/2024 at about 5 p.m. The accused managed to convince my daughter emotionally and took my daughter to his house. Thereafter, on 7/4/2024 at about 8:39 a.m., my granddaughter voice messaged me that her mother died. I suspect, my lord, that the accused person killed my daughter according to pre-plan. Everything would be revealed in investigation. Therefore, I request your counsel to arrest the accused person and take necessary action as per law.
From the date of LS incident, my lord, there was delay of 10 days in lodging the FIR, my lord. The LS incident that took place on 7/4/2024, and the FIR was filed on 17. Apart from that, may I take your lordship to the post-mortem report? The relevant page your lordship will find at page 26. The injury part, column 1. The injury is nil, my lord. The post-mortem report reveals that. And page number 27, the cause of death, your lordship. At 27, my lord, cause of death, asphyxia as a result of antemortem suicidal hanging. So, my lord, materials and evidence so far collected during investigation in respect of that complaint, it doesn't disclose about the commission of that offense, so less in the FIR. So, hence, for that, under that ground, my lord, I have approached before your lordship for setting aside, for passing that FIR lordship.
Case is still under investigation.
Charge sheet has been filed.
Charge sheet is-
At this stage, my lord, notice may be issued.
Yes, notice will be issued.
Notice may be issued.
And my lord, my humble prayer, the further consequential proceedings may be
My
stayed.
lord, otherwise at the time.
Only
of
charge sheet
framing
is
charge,
filed.
my lord, at the time of framing charge, that can be altered. my lord,
Recently,
at-
charge sheet is filed.
Now, see, obviously, he is rightly submitted that at the time of framing charge, it is the duty of the magistrate or the officer concerned to look over the entire materials. And if suppose, as you have submitted that it is the basis of the post-mortem report, maybe that may
Yes,
be the
yes.
one basis when the reported did a suicidal hanging. But apart from that, there may be some other materials, I don't know at this stage, which cannot be said. So if that be the position, it may be converted to from altered, maybe from 302 to 306 also. I don't know at this stage. Because there are some, why she committed suicide, that is the one of the reason of what was there
So
any
for the-
abatement? So that has to be considered.
So
So
for the
at this
content
stage,
of FIR, they
yeah.
suspect the, regarding the
obviously,
suicide
then,
all,
and as per you, was there any other else?
yes.
The minor daughter cannot do of these things, then who did? The question comes, then who did this? Your minor daughter, except your minor daughter and the wife or your deceased, there was none. Then who will do?
They live in a joint family, my lord. She was found hanging in the bathroom, locked inside.
There's no other allegation that the
Yes.
other family members had was
And in that FIR,
was
the
any
allegation is
tortured
that
her or thing. That's not that.
It's premature.
Very
It
premature.
should have come after, my lord, framing of charge, my lord.
Why, can we also notice may be issued.
Yeah, issuing notice করে দিও খালি notice issue করে দিব, call for the scan copy of the LC along with the case diary. No formal notice is required to be served, so also you can লিখে দিব list accordingly after 4 weeks. Such a case day cannot be there, we are listing it after 4 weeks. Let's see if case record or the case diary reveals nothing, then definitely maybe a case for acquittal, I mean squashing also.
Obliged.
Dibora.
Obliged.
Neatly, Your Lordship. This is an application under section 528 of the BNSS for Jimma custody of the seized amount of rupees 19,99,500, Your Lordship. Before taking Your Lordship to the impugn order, Your Lordship may peruse page number 116, Your Lordship. This is an order passed by the additional chief judicial magistrate before passing the impugn order. May I read, Your Lordship?
116.
16.
Hmm. Yes.
6th line, Your Lordship. From perusal of the case record, it is seen that the petitioner Solomon Ansari, I am the petitioner, Your Lordship. White petition numbers 758624 sought Jimma of rupees 19,99,500 seized in connection with the case, claiming actual owner of the aforesaid amount. So, Your Lordship, after that, a report was sought, little downwards, Your Lordship. A report was sought for from the IO concerned in respect of the aforesaid petition. The IO of the present case on 18/3/24 submitted a report stating that the aforesaid amount was seized in connection with this case. If the petitioner will furnish his source of income before the court, then the IO has no objection from his side. And subsequently, Your Lordship, the petitioner submitted all the relevant documents to substantiate the amount that he is the owner of the said amount. And thereafter, the learned trial court below question two issues: whether the aforesaid amount was seized from the possession of the petitioner at the time of occurrence, and second, whether the petitioner is the actual owner of the aforesaid seized amount. And thereafter, a report, again, it was fresh report was called for. So the said report is at page 123, Your Lordship. 123. May I read, Your Lordship? With reference to the subject cited above, I have the honor to report that Honorable Court had called for a report today on 8/7/2024 in connection with Jimma petition filed by the petitioner Solomon Ansari seeking the Jimma of the seized amount of rupees 19,99,500. I am submitting here with the report in pursuance of the said order. Number one, Your Honor, the amount of rupees 19,99,500 only was seized from the possession of the petitioner Solomon Ansari at the time of occurrence in connection with the Gauripur PS case number 447/22. Your Lordship, kindly it may be noted, as there were 4 accused along with me, 3 other accused were there. So they admit that it was seized from my possession. Secondly, Your Lordship, point number 2, Your Honor, the documents, papers which were produced by the petitioner Solomon Ansari in support of his source of income, duly verified by the concerned department and collected report accordingly. After collection of the details of his vehicle, it is came to light that the petitioner Solomon Ansari sold his vehicle. This is in regard to the documents which he furnished to substantiate his claim of the said amount. And thereafter, the IU verified the said claim. And last paragraph, Your Lordship. Your Honor, considering the above stated fact and circumstances, it is ascertained that the documents which he produced regarding his source of incomes are genuine, and he is the actual owner of the aforesaid seized amount of rupees 19,99,500. So, Lordship, even after giving the report, the learned trial court below has rejected his petition. And in this case, Your Lordship, FR has also been submitted. The final report is at page 100 and relevant pages at 110, Your Lordship.
So your impugned order is at 124.
124 to 128.
Yes. And where is the FR?
FR is at page 110, Your Lordship, the relevant page.
100?
110.
100.
The vernacular is at 111. I will be reading English, Your Lordship. The entire case is on 15/12/2022, the complainant Ritu Jyoti Nath, son of Mahinder Swenso, officer in charge of Gauripur PS, lodged an FIR at the police station stating that on 14/12/22, secret information was received that a large amount of money was being brought from Bengal in vehicle Swenso. Acting on this information,
Just I'm interrupting.
Yes.
This FR was filed on which date?
FR was filed on, Your Lordship, 30/01/2024.
30/01
2024.
2024. And your rejection order is on
Rejection was, Your Lordship,
29/8.
29/8/2024.
So in that regard, when the FR, the order was passed on 29/8/2024, have you placed the order of the FR that the FR has already been?
Yes, Your Lordship, it has been highlighted in the order, Your Lordship. I'll take Your Lordship to the relevant part. 124, at page 124, Your Lordship. Second paragraph. It is stated in brief that the petitioner is the owner of a grocery shop in the name and style of Alma store situated in the main market, Dhubri. The petitioner, along with 3 other persons, had gone to purchase articles from Kuch Bihar for the said grocery shop. The police, on mere suspicion, Your Lordship, seized the aforesaid amount of rupees 19,99,500 and apprehended them in connection with this case. However, the investigating officer, after completion of the investigation, submitted the final report in this case. So, this After considering the fact that the final report has been submitted, Your Lordship, since the trial court has erroneously passed the said order rejecting the claim of the petitioner, Your Lordship. And in the FR, Your Lordship, at page 110, it is clear that no substantial evidence or any criminality could be attributed to the petitioner, Your Lordship. It is clear in second paragraph at page 110. May I read, Your Lordship? During second paragraph, Your Lordship, during the investigation, the crime scene was inspected and statements from the complainant and other witnesses were recorded. It was revealed that the accused so-and-so is involved in the sand and stone business and exports to Bangladesh. The accused Sanidul so-and-so, driver of the seized vehicle, on 14/12/2022, collected cash rupees 19,99,500 in cash from Kuch Bihar, which he had received for his business transaction. Along with others, he was traveling from Kuch Bihar to Gauripur in said Maruti Swift car. The money and the vehicle were seized based on the suspicion that the accused were transporting the money to Bangladesh through Hawala transaction. However, during the course of the investigation, no substantial evidence was found to prove that the accused had illegally obtained the money. Therefore, due to the lack of sufficient evidence, the final report is being submitted with the conclusion that the case cannot be proceeded further. The concerned investigating officer has communicated this to the complainant via WT message. And last line, Your Lordship, however, after a thorough investigation, due to the lack of sufficient evidence, I request that the accused persons are discharged from liability in this case. And
Your petitioner's name is?
Suleiman Ansari, Your Lordship, number 1. Several
But as per FR, the money was collected by Pradhani, Sadiqul Haq Pradhani.
That is an allegation, Your Lordship, that in Kuch Bihar, the main gist of the story in reality, it's that, Your Lordship, I am a small businessman who was running a grocery shop in Dhubri main market. But then I thought of expanding my business, Your Lordship. So in relation to that, I also have annexed agreements, several agreements and gift deeds, from which I allocated some amount so that I can go for marketing and to Kuch Bihar and expand my business after bringing some materials from there, and I'll sell in my grocery shop because I have a family who are all dependent on me, Your Lordship. So, but thereafter I came back because I found that the amount of money which for the materials were high in price. So I came back. And while coming back, they police seized the amount, Your Lordship. And I have also annexed all the documents at page. I also have my trade license, Your Lordship, at page 41 to 44. Now, because I'm going through financial hardship, Your Lordship, since the money was seized in the year 2022 and now it's 2025. So the said shop is not in operation and just small shop I'm running now. So I'm going through financial hardship as well as losses, Your Lordship. And while going through this petition, Your Lordship can see that no criminality could be attributed. In the FR also, they have submitted that it is clear that they merely had a suspicion in regard to the amount, but it is clear that no illegality has been obtained. And initially, Your Lordship, this case was registered also under Section 4 of the PMLA Act. But then, due to as the jurisdiction was not there, and multiple times it was forwarded from one court to another. And lastly, when the learned special judge Assam Guwahati, it also, the order is also annexed here.
No, after filing of the Bhattakur, after filing of the FR, the sir rightly observed that unless and until from the informant side it is, so notice was issued, I think. So accordingly, the date was fixed for appearance of the informant. But while dealing with the order, by passing the order, additional CGM is that they from the FR and other perspectives also, it is seen that he is not the actual owner of the entire amount. And that's what I was asking the council, that because in the second para which was reading, therefrom it is also seen that it was not the money, is nowhere it is mentioned. If you go by the FR also, just see the page 110. It is the driver who collected the money, received the business for transaction and all. Sadikul Haq Pradhani was the driver, is alleged to be driver.
Yes.
And the seized, which were supposed to, just for Hawala transaction and all those money were actually transported. These are
Yes.
things. But during investigation, there is no mention at all
Yes.
that he is the owner, in fact, the actual owner.
Only
But obviously, it is admitted fact that the FR has already been submitted.
submitted and in the report subject to verification.
Ah.
Subject to verification of the amount, my lord, that in that report of the IO, he has stated that. And regarding now in the trial court order, assessment here has been stated as, my lord, not which was submitted by the, my lord, before the trial court.
At the time, your lordship, some other assessment year was given, because when the amount was seized, it was December 2022, your lordship. Then how the person will that the amount which is showing as which I am claiming, how will that person show in the March 2022, your lordship? Because thereafter the agreement of sale deeds and everything was happening, and through that only I allocated the amount so that I can expand my business. Your lordship will see.
But why there's nothing has been mentioned in your FR while filing the FR that these are the
Otherwise,
things.
monies are, my lord,
assets.
there since long. What we.
It's in Treasury Office, your lordship, in Dhubri.
Yes,
And
Treasury
I
Office in
have
Dhubri.
filed multiple applications, and it
Now-
is not considered, your lordship.
Now,
And
but from the order passed by the Tribunal order, it is seen that that FR is not yet accepted by the State concerned. So that's why the notice was issued to the informant. This is a procedure, in fact. So that is there. So now, yes, what can be done?
From the prima facie, it seems that it is a case of, my lord, income tax, my lord. The police has to send the, my lord, all these, if, my lord, source cannot be verified, the police, my lord. From the records, it reveals.
but your lordship,
She
now,
pointed out one para in the
Yes.
report when it
Regarding-
was called for,
Yes.
wherein it is most probably held that the actual owner of so and so, but the income tax so and so not
there is
there.
no such complaint, your lordship, till now.
And, my lord-
It's been more than two years and 2
Hmm.
months now. So there is no such complaint by any person as section 420 and 413 is alleged against me. Nobody has claimed that somebody is cheated or I have stolen some property. There is nothing. Your lordship will peruse the bail
Then-
order
then
as
what
well.
to do?
At
Call
this
for?
stage, my lord, LCR may be called for, my lord, fixing a short date, my lord.
Scan
And on that
copy.
day, my lord, scan copy of the LCR.
Now, apart from that, do you have any idea, because that's the impugn order which you have annexed?
Hmm.
There, the date was fixed on 23rd of September 2024, asking the informant to appear. What happened? Do you have any idea whether the FR is already accepted?
Just a second, your lordship. I'll just check. Your lordship, after the FR was submitted and since multiple dates were passed,
No,
calling for the
it's okay.
report.
FR was submitted, there were passed, and the last order you have annexed here.
Yes, your lordship.
That is the order of the rejection also, as per the
Yes.
order is there, wherein it is stated that the case is fixed on 23rd of September
September,
2024 for appearance of the informant, so that informant deposition or the informant statement can be recorded and the FR may be accepted, may not be. That
Yes.
is up to the
Yeah.
concerned court. Do you have any other instruction whether
I'll
the
have to take
in regards to acceptance of the FIR? That's what I'm saying.
I'll have to check, your lordship.
And, my lord, let her get the instruction after 23/9/24, what happened in the present status.
No, in the meantime, if you call for the
Yes,
scan
scan.
copy of the
Yes.
record along with the present status,
Present
then
status of
come
the-
Yes,
Yes.
come to us.
yes.
Because it's a amount is 19 lakhs is a huge amount, and obviously if
Yes.
if you are the actual owner, then obviously there will be huge loss on your part also, but
Otherwise,
in
funded
terms
report
of
also,
income tax assessment report, etc., I don't know, we have filed. funds.
I have given the IT return and everything, Your Lordship. It's there in the record itself.
For which year you have given?
23, 24, because in December 22, it was.
Because,
seized.
but the case was of 2022.
Yes.
So in that case, the amount which was with you or whatever, is there any income
Yes,
tax
there- it is
assessment
hi-
report
yes,
is there
Your
in
Lordship.
now?
It's highlighted at page 57, Your Lordship. Let me kindly peruse. I've given the balance sheet as well as,
57.
yes, at page 63, Your Lordship. May I kindly peruse. It's the balance sheet and it's audited balance sheet. One for second, third, gift money received from father, so and so amount. Thereafter, at page 60, Your Lordship. Of, deposit and advances column. Cash money seized by Balajan OP on 14/12/2022. 19,95,000, 99,500. It is showing. And I have also paid my ITR, Your Lordship, at page 57 is there. This is the ITR return. Receipt of the ITR.
Okay, at this stage, most probably it will be convenient for us to call for this, along with the present status report, if it is there. Come for. You are MS?
S. Jane.
S. Jane. MS S. Jane, huh? Rastrata Sanam. Also heard Mr. P. Waterpool, the learned counsel for the petitioner. Sorry, response state respondent. Here, state is the only party, I think.
yes, sir.
Only respondent. Issue notice of no formal notice is required to be served. After hearing MS Jain, it is also seen that in the instant case, the police, the investigating officer has already filed FR, FR, due to lack of the proper evidence. But after filing of the FI, it seems from the impugn order that the notice was issued to the informant for his appearance, and there is no other status of the case as to what happened after the issuance of notice to the informant. In view of this and considering all aspects of the case, this court finds that the scanned copy of the LCR along with the case diary and the present status report of the case we call for. List accordingly when it can be listed after 3 weeks.
Short date, Your Lordship.
Short
Before
date.
BU if possible with the
Before BU is not possible.
On
That will be
24th
after BU only.
24th of April.
24th.
24th,
Fourth. Okay.
24th.
In connection.
24th of April.
Your Lordship, may I highlight the name, case number, Your Lordship?
Obviously, it will
order.
be highlighted. It will be highlighted.
Obliged.
Highlight koi dibo kuntu case lage. Case record which we are calling for, it will be highlighted.
Quarrypool case.
Yes.
20.
May I please
Yes.
your lordship? Lordship, there was an FIR against me. The Ezahar is at page 15 for allegation of stabbing and killing the brother of the informant. Ezahar is at page 15. Now, date of the offense, he has mentioned at 4 p.m. on 16/6/2017.
Yeah.
I'm just highlighting the date of the offense, 16/6/2017. Now, Lordship, thereafter he was arrested on 18/6/2017. And
16/6.
16/6
is
date of the
time
offense.
of date of occurrence, and as well as the FIR is also lost.
Yes. Then 18/6/17 he was arrested. Till now he is in judicial custody. He is continuing as under trial. Then Lordship, he filed a bail petition. Bail petition before the learned CJM Sonipur on 11/2/17,
And in the bail petition,
11 to not 17.
sorry,
18.
18. In the bail petition, Lordship, he had taken a plea that he should be treated as a juvenile. For that, he had enclosed his school certificate, which is at page 21. School certificate, type copy at page 21. Sonitpur ME school living certificate. Here, Lordship, third line, his date of birth is 7 to 2001. 7 to 2001. And date of offense is 16/6/2017, as I've already stated. So on the date of offense, he is 16 years, 5 months, 9 days. So, but his bail petition was rejected. Order is at page 23. 23, order dated 17/8/17. I'm reading this order, Lordship. Seen bail petition number so and so along with a certificate filed by the petitioner, page 23, Lordship. Seen bail petition number so and so along with a certificate filed by the petitioner praying for holding the accused as juvenile. Heard both sides. I have gone through the certificate and found that the certificate was issued by the headmaster Sonitpur ME Madrasa, and moreover it is issued only on 10/8/17. Hence the petitioner is directed to furnish a certificate issued from LP school, if any, or birth certificate and any age of document. Considering all the petition filed by the petitioner for holding the accused as juvenile is hereby rejected at this stage. At this stage. So this is gone now. So it was rejected at this stage. At that stage. Thereafter, Lordship, the FIR culminated into a charge sheet. He has participated in the trial, and Lordship, during the trial, also he filed a bail petition that was rejected, and he's continuing in the custody. And thereafter, Lordship, matter has now come to the argument stage. At the argument stage, he has filed one petition. This petition, your Lordship will find at page 33 to hold him as a juvenile. To hold him as a juvenile. This petition is at page 33, and the impugn order, your Lordship will find at page 35. Impugn order, operative portion I'm reading, Lordship, page 36. Page 36. Perusal of record reveals that a plea of juvenility was taken by the accused by petition number so and so on 17/8/17 before the learned Chief Judicial Magistrate Sonitpur Tezpur. The accused, in support of his plea, submitted one certificate issued by Headmaster Sonitpur ME Madrasa, Koro in so and so Tezpur. The learned committal court, after hearing both sides and considering the said document, rejected the prayer at that stage with a direction to the accused to furnish a certificate issued from any LP school or any birth certificate or any other relevant age proof document. Perusal of record further reveals that thereafter the accused neither produced any age proof document as directed by the court nor raised the plea till today. It is also seen that the accused also did not challenge the order dated 17/8/17, whereby his plea of juvenility was rejected. Therefore, considering above aforesaid facts, I find that the decision rendered by the learned CJM Sonitpur Tezpur by the order dated 17/8/17 in this issue reached finality, and as such the same issue cannot be raised when it has already been finally decided. Now, Lordship, that order was in the bail petition, and bail petition, as your Lordship is well aware, Lordship, it is a prima facie without appraisal of oral or documentary evidence in toto. So, Lordship, now since evidence, this issue has been raised in the trial stage. So, order in the bail petition can in no manner be a precedent while deciding the his case regarding juvenility at the final stage of after holding trial, detailed trial. So this finding that it has attained finality, this finding is not correct. It is like an interim order, Lordship. Interim order, it is is a tentative finding based on prima facie opinion, and it cannot have a effect of a precedent. So, Lordship, and here, Lordship, I could not produce the LP certificate. LP certificate was not available with him. So he has also made the headmaster of the LP school party respondent in this particular petition, and the Sonitpur ME certificate is also enclosed, and it is a valid certificate issued by the office of the headmaster Sonitpur ME Madrasa at page 21. So it clearly states my date of birth to be 7/2001. And considering that date of birth on the date of offense, I am 16 years, 5 months, 9 days.
And now the matter is fixed for argument. Argument next date is fixed on 27th of March. So before, without deciding issue, if the matter is taken up for argument and finally decided, then this will also become infructuous and he will also suffer irreparable loss.
Otherwise, my lord, any other school transfer, I have gone through the certificate, on the certificate issued by the headmaster. There are some criteria, some guidelines is there in our Juvenile Justice Act, in the what manner, my lord, juvenility can be decided. So now, my lord, that order was passed on 17/8/2007. That is in a bail petition. He is right in our, my lord, he is making his submission that, my lord, in a bail petition that cannot juvenility of a, my lord, accused cannot be decided, my lord. Now, my lord, otherwise, till now, while he has, till now, he has not submitted any document regarding the genuineness of his, my lord, even a birth certificate or otherwise, my lord, your lordship can, before final argument, yes, it need to be required to be decided. The, my lord,
No,
the,
but who will decide? We are not the court to decide the juvenility at this stage. At best,
Yes.
we can call for the, I mean, what to say? It has to be, the order has to be there to decision judge to decide the matter otherwise.
Yes.
At this stage, you want any other further clarification from that regard?
They may decide. But
otherwise, since 2017, my lord, he has
Yes.
not raised that plea.
Ah.
Now, my lord, after a while, at the
He
time
faced
of
the entire trial.
argument only to delay the trial, when he has raised this argument at this point of time.
he was lordship
Allegation
all,
is also very serious allegation.
he's all throughout lordship in the custody lordship. He could not produce the document for that reason also. Lord.
Let at the time of argument also, my lord, if he has any document at the time of argument also, now he can produce, my lord.
Now, have you filed? Oh, acha, he has already filed one petition, I think.
I have filed a petition.
But then at the time of argument, he can place solid document and on the basis of those documents, he can make his argument, my lord, because if all those documents are there in the record.
Simple document will not sufficient, I think. That is.
Those are difficult.
With liberty to adduce evidence, lordship. Matter may be decided by trial court with
And liberty, man, while deciding the matter, trial court will do is
Right.
needful.
Yes.
If required, then the headmaster of the
Yes.
will be
Yes.
maybe recorded. That will be one of the aspect.
But they have closed the matter on technical ground of attained finality, which is my learned friend has rightly admitted that it is not correct.
Yes, it may not be correct.
To decide the juvenility. my
You are
lord,
you are
Jesus
legal aid
Sharma.
counsel.
Yes.
Legal. Hard meter, Mr. G. Sharma, the learned legal aid counsel appearing for the petitioner, and also heard Mr. S. Portaco, P. Portaco, the learned additional PP appearing on behalf of state respondent. This is an application, so and so, so and so. It is submitted by Mr. Sharma, the learned legal aid counsel, that the incident, the date of incident took place on 16/6/2017, and and on the same day the FIR was also lost, and subsequently the accused petitioner got arrested on 18/6/2017, 18/6/2017, and since then he is in custody. He filed the bail application before the learned trial court below taking the plea of his juvenility, wherein he also produced this full certificate issued by, who issued this one, full certificate?
Sonitpur.
ME,
ME.
issued by headmaster Sonitpur ME Madrasa Koraini, 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 Koraini. Which district it is?
And my
Sonit-
lord, whether that
Sonitpur.
document now is on record in the school, my lord, in the
Koraini, wherein his date of birth is recorded as 7/2/2021, and thus at the date of occurrence, he was 16 years, 5 months, 9 days old and was a juvenile. But the said bail application was rejected by the learned trial court below by order dated 17/8/2017 with an observation
Twenty-three page.
that the certificate was issued only on 10/8/2017, that is after the occurrence, and accordingly directed to furnish the certificate issued from the LP school or any other birth certificate, etc. And the plea of juvenility was accordingly rejected at that stage. Full stop. However, thereafter, no subsequent bail application was filed by the present accused petitioner, and he faced the trial accordingly. And at present, the case is at the stage of argument. Full stop. At the stage of argument, the petitioner filed an application before the learned additional session judge,
Yes,
Sonitpur,
FTC.
Huh?
FTC. First Trade Court.
additional session judge, FTC Sonitpur. He did not answer line to first. Sonitpur, taking the plea of juvenility, and the said plea of juvenility was rejected by the learned additional session judge FTC by its order dated 11/9/2024, wherein it is held that decision rendered by the learned CGM Sonitpur, Tezpur, by order dated 17/8/2017, in this issue of juvenility had reached the finality, and as such, the same issue cannot be raised when it is already finally decided. With that observation, the plea of juvenility was not considered by the learned additional session judge, and hence, against the said impugned order, the present petition has been filed by the petitioner. It is submitted by Mr. Sharma that the order was passed. The learned additional CGM had passed the order on 11/2/2018. Right? Yeah.
No.
No.
17/8/17.
Oh, sorry, 17/8/17. Only in connection with a bail order, wherein the petitioner paid for bail on the ground of his juvenility, which is purely an interlocutory order, and hence that cannot be considered as a final order, or it cannot be held that the issue had reached the finality. Next para. He is the LP school headmaster,
Yes,
the number 2.
yes.
He further submitted that he could not collect, or he could not produce the LP school certificate. However, the headmaster of the Bhojkua, BHOJKHOWA Sapori LP school is also made a party respondent number 2 in the present case. Next para. Mr. Botaku, the learned additional PP submitted in this regard that the present petitioner can also raise this issue even at the stage of argument before the learned session judge, taking the plea of juvenility. And however, he admitted that the order, admitted that the observation made in the order passed by the learned additional session judge is not proper, as the order passed in a bail application cannot be considered as a final order, or neither it can be held that issue was finally decided while dealing with an application for bail. Next para. Considering the entire facts and circumstances of this case. No. Like, after hearing the submission made by learned counsel for both sides, it is seen that the plea of juvenility was taken by the present petitioner at the time of after his arrest, while filing a bail application before the learned committal court, but thereafter he faced the entire trial without taking any such plea of juvenility, though there was a juvenility, and only at the stage of argument he came with a plea for juvenility. However, it is a settled law that plea of juvenility can be raised at any stage of the case, even after the final disposal of the net case. In view of this, and considering all aspects of the case, I find that, and I hereby direct the learned additional session judge FTC Sonitpur, stage 4, to make an inquiry in regards to the juvenility of the present accused petitioner, complying all required formalities, and he will also be at liberty to record evidence of any witnesses, record evidence of any person or witness if required during the inquiry. But thereafter, we are not 40%. He will dispose of the matter of the juvenility, and accordingly, the learned additional session judge will hear the matter and dispose of the matter accordingly. Argument will be stayed, no. Otherwise, it will be hard if it till the plea of juvenility decided by the learned additional session judge FTC. The hearing of the argument may be stayed. However, the learned session judge will be at liberty to fix a date for argument or further proceeding after deciding the plea of juvenility. With the above observation, the present is disposed of. Copy has to be copied to automatically go, I think. Copy of this order be served to the learned additional session judge FTC Sonitpur Tezpur for necessary to do the needful.
And the petitioner who has also not produced any document from 2017, he is also required to go and submit all those documents by which he claimed juvenility, my lord. Regarding other documents, he will place the documents, my lord.
The petitioner will also produce the document to prove to substantiate his plea of juvenility, if any. If he has any document, then he can produce. Otherwise, most probably he is not having any document. You are not having any document, I think.
But he can bring in he can bring in witness.
Obviously. That's why your headmaster is also there.
Deeply of
Okay. Disposed of.
May I please, your lordship?
Yes.
This application under section 528 of BNS has been filed for passing of order dated 28/5/2024. And my lord, the judgment dated 19/2/2025. Before going to the merits of the case, my lord, I would just like to apprise this lordship regarding the factual background of this case, my lord. So what happened in this case, my lord? The respondent number 2, being complainant, filed one case under section 138 of the NIA against the petitioner, lord. The case was at the stage of argument. At that point of time, Lordship, the petitioner engaged a new set of counsel. And it was for the first time disclosed to the new set of counsel that corresponding to this particular case regarding the dishonor of check of rupees 2,50,000, another FIR was also lodged before the Gorsuk police station, wherein it was stated that when the complainant went to the residence of the petitioner to demand the money, she was threatened by the petitioner and her husband. Accordingly, a case under section 406, 420 was registered by the Gorsuk police. That case has been registered as Gorsuk PS case number 118 of 2013. Under section 120B, 406 and 506. So mentioning regarding the dishonor of the check in both the cases, in the FIR of the GR case also, in the NIA case also, that is the core issue, my lord. Thereafter, one application under section 311 was filed by the petitioner for recalling the PW1, that is the respondent number 1, in order to confront her with respect to the contents of the FIR of the GR.
For recalling PW1.
PW1, that is the respondent, my lord. For in order to confront her in respect of the contents of the FIR of that Gorsuk PS case. Subsequently, that petition was rejected by the trial court, my lord, and accordingly, one revision petition was filed. During the pendency of that revision petition, on the 311, my lord, the case was surseated. Gorsuk PS case was surseated. The petitioner and her husband received the summon from the learned trial court. They appeared, and the case has been registered as GR case number 3850, and the same was pending, /13, same was pending before the learned judicial magistrate first class court. In that particular GR case, my lord, the respondent number 1 adduced her evidence as PW1.
In that case also.
In GR case, my lord. That case is pending, my lord. In the revisional stage, that case was pending. NI case. In the GR case, she already tendered her evidence. After tendering the evidence, all the evidence were taken into note, and lordship, they were finally acquitted. I am not on the acquittal of the petitioner. Just I am apprising your lordship.
Acquitted.
We were acquitted in that particular GR case, my lord. And thereafter, lordship, the revision petition was dismissed by the revisional court. That 311, under section 311, that revision petition was dismissed by the revisional court. And subsequent thereto, lordship, the matter was remanded back to the trial court for disposal. The case was at the stage of argument. Thereafter, petitioner filed an application under section 294 of the CRPC in order to calling upon the respondent in order to admit or deny the evidence adduced by her in that GR case. Why it was necessary, my lord? Because there was discrepancy, material discrepancy in evidence tendered by the respondent number 1 in GR case number 3850 in respect of the lending of the money. Because in the NI case, my lord, she has stated that the money was taken in the year 2013. But in that particular GR case, while adducing her evidence, in her evidence in chief only, she has stated that money was taken in the year 2011. Furthermore, lordship, in the NI case, she has stated that the money was given at one go. But in the GR case, she has stated that the amount was taken at various installments. So in order to bring this particular discrepancy into the record, an application under section 294 was filed. That application was subsequently rejected by the learned trial court. Lordship will now come to Annexure 3, my lord, page 31. That is the order of the learned trial court, order dated 28/5/2024. Page 32 is the relevant, lordship. I am just reading out the relevant portion. After hearing both sides, this court on 28/2/2019 rejected the prayer of the accused for calling the above mentioned case record and for recalling PW1. That is the earlier application, my lord, 311. Thereafter, the accused side being aggrieved by the order of this court preferred a revision before the Honorable Additional Session Judge number 1, but the Honorable Additional Session Judge number 1 in criminal division case number so-and-so has rejected the prayer of the revisionist. Again, the accused side has came up with a plea that they want to call upon the PW1 to admit or deny the genuineness of the certified copy of the evidence tendered by PW1 in GR case number 3850 of 2013. From the perusal of the record, it appears that already the prayer of the accused for recalling PW1 and calling the record of Gorsuk PS case was rejected and now again filed the same prayer. though it was not the same prayer, my lord. But the learned trial court has construed the same as the same prayer. Same prayer under the different provision of the law. As the case is already in the evidence stage, the accused has given the chance to adduce evidence during the DWs. But as he failed, now at this stage, he cannot be allowed to fill up the lacuna. It is pertinent to mention herein that the prayer of the petitioner number 2 is allowed at this stage, then it will vitiate the object of section 294 of the CRPC, which is a speedy disposal of the case. It is also to be mentioned that what you cannot do directly cannot be done indirectly, as already there is a standing order regarding the prayer of the accused under section 311 of the CRPC. Now, this court cannot go beyond that order. Hence, considering the above aspect, the prayer of the accused is rejected, so and so for argument. Now, Lordship will kindly come to the page number, Lordship, 39. There is the order passed by the judgment passed by the revisional court. Para 9 is relevant, my lord. Apparently, the petitioner, page 39, Lordship is got it. Page 39, Lordship, para 9. Apparently, the petitioner has filed a petition belatedly at the stage of at the argument stage, only to fill up the lacuna in not adducing evidence in support of his defense. The provision of section 294 of the CRPC has been wrongly invoked. The certified copy of the oral evidence adduced in another case cannot be considered as a document within the meaning of section 294 of the CRPC. The provision of section 294 of the CRPC cannot be read in isolation. The provisions of the Evidence Act from section 40 to section 44 must be kept in mind. The petitioner was acquitted in ZR case number 3850 of 2013. The petitioner is expecting to derive the benefit of that acquittal by making the oral evidence adduced by PW1 in that case as a part of the record in CR case number 1333 of 2013. However, the provision of the section 43 of the Indian Evidence Act provides that the judgment, order, and decree in other cases, except those provided under section 40, 41, and 42 of the Evidence Act, are irrelevant unless the existence of such judgment, order, or decree is a fact in issue or relevant under the some other provisions of the Evidence Act. This was the observation made by the learned revisional court. My contention is that, my lord, section 294. What does it speak, my lord?
No, this after your 311 petition, you have moved an revision petition.
Lordship.
For the revision that was
Lordship.
rejected.
That was rejected.
But there also you took the plea of 294, I think.
No, Lordship.
Then it is the
At this
observation of
stage,
294 because
that point-
294 filed by you only before the learned magistrate or where?
Learned magistrate. Subsequently,
Then when it was rejected, then again you move
yes,
for
Lordship.
revision.
Yes, Lordship. Now, my only contention is that, Lordship, section 294, that has been wrongly construed by the learned trial court as well as by the revisional court, because the object of the section 294 is that, my lord, no formal proof of certain document. Where any document is filed before any court by the prosecution or the accused, the particulars of every such document shall be included in a list, and the prosecution or the accused, as the case may be, or the pleader for the prosecution or the accused, if any, shall be called upon to admit or deny the genuineness of each document. My only contention is that, Lordship, that evidence has already been tendered. There is material discrepancy in the evidence that has been adduced in the NIA case as well as in the ZR case. So, in order to bring that into the record, my lord, 294 was filed. And so for 294 is
Why didn't you take now what was the stage of the case when you filed this one? The argument stage.
Argument, because, Lordship, because earlier the petition was filed during the pendency of this revision petition, evidence was tendered. Lordship will kindly see the date when the evidence was tendered. It was only during the pendency of that revision petition, my lord. So at the earliest point of time when the case was remanded back to the learned trial court, I have filed this petition. It was tendered on, Lordship, 14 August 2019 by PW1. That is the respondent has tendered her evidence on 14/8/2019. At that point of time, the revision petition was pending before the revisional court, my lord. And subsequently, the revision was rejected and the case was remanded back. At the very inception, after remanding back the case, we have filed the application under section 294. Now, purport and object of the section 294 is that, Lordship, we have already tendered the certified copy of the evidence of the PW1. The learned trial court was only to call upon the party in order to admit or deny lordship, nothing more than that. And if we do not bring that particular document into the record, my lord, it is a case of 138 lordship. There is a mandatory presumption under section 139. My entire report will be gone, my lord, if that particular statement is not recorded in the do not come into the evidence, lordship. And that is the previous statement. If your lordship kindly, just I am reading out the first paragraph, lordship, on which I am banking upon, lordship, why I want to bring that particular document. Lordship, page 17, annexure 1, lordship, just first paragraph. Incident took place in the year 2019. In the year 2011, the accused had borrowed money from me several times, total amounting to rupees 2,50,000 for 6 months. On 15/12/2011, the accused borrowed money from me. After 6 months, I tried to contact the accused, but she avoided me. This is her statement in chief. And lordship, what is her contention in the NIA case is that, lordship, the amount was given in the year 2013 and the amount was given in at one go. That is her evidence in NIA case. Material discrepancy. My only contention is to bring, my only effort was to bring this particular evidence into the record so that that may be read in evidence. Because under section 294, there is a specific provision, my lord. If that is not been disputed, genuinity of the document is not been disputed by the side, either of the side, that will directly read into the evidence. It is a work of one day, my lord. We have already furnished the service copy.
He has brought it for any service.
Well, the learned trial court has rightly passed the order, my lord. Your lordship may kindly come
Seems to
to
be.
page 38, my lord. My lord, the decision, my lord, discussion and the reasons there. Here, my lord, learned trial court, there is nothing to interfere in this order, my lord. Otherwise, my lord, while passing that order, my lord, learned trial court has also discussed, my lord, various provisions of the section 294 and other provisions, and my lord, and the citations, my lord, it is a settled position of the law, my lord, case 40, that every case is to be decided on the basis of the evidence adduced in that particular, and the evidence adduced in other cases cannot be considered, my lord.
Okay, then we'll do one thing. The case is at the stage of argument, in fact.
Yes, ma'am.
So already delayed. If it is delayed, then
That
Lordship, I am just
okay,
relying
then
on
we'll issue notice and is case at the stage of evident argument. Notice has to go to respond number 2, I think. Otherwise,
Lordship.
wait. Notice to corridor, respond number 2, to register aliens. Also call record will be required, but not required.
maybe issued. If my lord, opposite party.
One of the records
can
be,
appear, then my lord, everything will be, my lord, clear.
my lord,
Because
records be
otherwise you
required.
have already submitted this date.
Record will be required because lordship will have to ascertain the fact that whether there is a material discrepancy or not. Why I want to bring.
We have
this
already
record.
given the certificate
Everything
copy,
is
these
there,
are or
my
not.
lord.
Certified copy of the judgment and order, my lord, and the evidence rendered in the GR case, my lord, not in the NI case. That is not part of the.
NI you have not bring.
No, lordship, that is the part of the record, lordship.
Call for scan copy of the case record. And till next date of listing, it will be stayed, otherwise matter may be fractures
It
also
is-
because in
Lord.
argument is there, na?
Lordship,
What will be stayed only till this date of listing. Matter may be heard and finally decided on the next April, but again, if it is
the
the
issue is very much small, lordship. Lordship can decide on the next date itself, after going through the record, whether there is a discrepancy or not, and whether both the learned trial court as well as the revisional court has interpreted the provision of section 294 rightly or wrongly.
Otherwise, my lord,
That is the moot question. before you.
everything was rightly discussed by the trial court, my lord. And my lord.
Because
Apparently
that
it
cannot
seems-
be taken as par, lordship. 311 is totally different and 294 is totally different. It will not waste the time of the court, lordship. 294 only calling upon the party in order to admit or deny the genuineness of the document. He is not supposed to come to the witness box. He is not supposed to be confronted with the document, lords. He will simply deny or admit that this is, yes, this is the evidence I have rendered, or this is not the evidence that I have not rendered. That much. 311, lordship, we have to confront the witness in respect of the document and all this. So it will consume time, definitely.
So 311 and 294 cannot be taken as part lots.
It is submitted that the petition for 294 CRPC was rejected by the learned trial court below. And as well as the learned revisional court, and hence revisional court, without going into the without going into the fact that the 311 CRPC and 294 CRPC is a different provision of law. এইখিনিতে লিখি থৈ দিয়ক হা আৰু the case is at the stage of argument, and hence if there is no stay in the order of placement, the purpose of filing the present petition will become infructuous. Stay করে দিব next date of listing on the list after 4 weeks. Okay, we'll listing after 4 weeks.
We'll take
calling
the
for
issue notice.
notice. It will be stayed still next date of listing.
Lordship notice within Lordship, within 1 week. Lordship.
Within one,
Lordship.
it takes steps.
Obliged, Lordship.
May I please the Lord? My Lord, this application is filed under
ইমান
section
criminal
20.
petition একেলগে দিয়ে দিবি। হ্যাঁ। ইমান দুখৰ কথা নহয়। These are not so urgent number. Yes.
May I please the Lord? My Lord, this application is filed for quashing the proceeding against the petitioners, my Lord, who are old aged ailing persons, my Lord. They are made party in a domestic violence case, my Lord. So, prima facie, my Lord, there is no specific allegation.
Who are they? How they are
They are the
related?
father-in-law and mother-in-law, my Lord.
Oh, then it's okay. Father-in-law, mother-in-law are the necessary party.
My Lord, they are staying separately as
Oh,
it
but
is on record.
they are the marital relationship is there. No?
And my Lord, there is no specific prayer of any restraining order against the petitioners, my Lord. Because it is a domestic violence act, it is the nature of domestic violence act is of prohibitory nature. My Lord, orders are generally of prohibitory nature. Why, my Lord, they are not staying together where there is no allegation of any domestic incident since last 2023 against the petitioners. So why prohibitory order is required against these persons? My Lord, because they are staying separately, divorce proceeding is going on. Husband is a necessary party in this case, my Lord. But these are all ailing persons, my Lord, only to harass them. They are made party in this case.
So
Well,
what is the
especially when,
stage
my
of
Lord,
the case? Cognizance has been taken.
Yes, my Lord,
Cognizance has
yeah,
been
we filed an application for releasing them from the case, discharging them. It was rejected. That's why we are before your Lordship, my Lord. My
Where
Lord,
is the
kindly
order?
have a look.
Order?
My Lord. Order is that, my Lord. Page number 153 to 156. Before that, may I bring your Lordship attention to page number 128, my Lord. Only very short prayer, my Lord. On page number 128, my Lord, last paragraph. The in-laws, page number 128, my Lord. The in-laws, my Lord, bottom, third line from the bottom, my Lord. The in-laws of respondent have never complained about her to her parents. And also she has never quarreled with her in-laws. Instead, the father-in-law quarreled with his son petitioner and left his rented house and stayed with his eldest son at Hozain. This is her written statement in the divorce proceeding, my Lord. She has herself stated that we have argued with our son. We have no complaints with hers. This is her statement, my Lord, not our statement. This is the written statement filed by her in the divorce proceeding, my Lord. So at this stage, my Lord, kindly the proceeding may be stayed against the petitioners, my Lord, not against the husband. We are not paying anything against the husband.
No, see, petitioners, it cannot be stayed because petitioners are the mother-in-law and father-in-law. It cannot be stayed.
Her statement may kindly be once considered.
Whatever. It cannot be stayed.
My Lord, may kindly go through it.
No, it cannot be stayed. Mother-in-law, father-in-law is a necessary and required party.
Well,
Here in this case, my lord,
What?
father-in-law and mother-in-law, latest case, my lord, 2025, my lord, it is said that father-in-law and mother-in-law should not be unnecessarily harassed, my lord.
Unnecessary harass different thing, but here is a, your allegation
When
has
there
been
is no
brought against
specific,
you.
my lord, when there is
That
no,
will come later on. But now at this stage, we cannot stay the order.
my lord, they are.
Your petition may be allowed. I'm not denying it. Your
Ah.
petition may be allowed. There may not be any materials.
Ah.
These are all right. But in now question, it cannot be stayed. Your petitioners cannot be stayed.
Only
The
except
father-in-law
petitioners,
cannot
my
be
lord.
stayed.
Kindly have a look at this.
No, it's okay.
It's very new, my lord.
No, whatever.
Here it is, when there is no specific allegation, it is clearly stated, my lord. When there is, and in this case, my lord, there is no specific allegation. There are two domestic violence cases, my lord. Initially, she filed one that was withdrawn, not a single statement against the parents.
What?
And
okay,
they
fine.
stay, they are staying separately, ma'am. Only her statement that we had good relationship with her. It is her statement, my lord, not our statement. And my lord, only for the sake of unity, my lord, they are ailing persons, my lord, presence of authorities. They cannot even move properly. They from Hosai, they have to come to court.
Each day, each and every day, their appearance is required in DP case. I don't think so.
Yes.
He may be, they may be represented by this and this council also. It's not required that every day. It's not a, it's a quasi-civil or quasi-criminal proceeding.
Yes, my lord.
So here it's not required, all this.
My lord, may kindly have a look at the
Don't
citation,
have
my
time,
lord.
in fact.
That is very new, my lord.
Yes, yes, whatever you see, one which para.
My lord.
Yes, we have marked it, I think. I have seen
Yes, yes.
29, para number 29.
35 also, my lord.
Yes.
33 also, my lord. I have marked. My lord, may pass the order later on, my lord, may have a look at that.
No, no, you're passing it now only. These orders are passed in a criminal appeal, I think, na?
Yes, and another thing, my lord, first we filed
It was against the quashing proceeding or it was finally disposed of?
this order, this passing proceeding, my lord. It was rejected by the Honorable High Court, then, my lord.
No, no, the Supreme Court.
Yes.
Its observation is all right. I'm
Yes,
also
yes.
on that there may not be any material. I'm saying on stay. Stay cannot be there. That's what I'm saying.
Only against the petitioners, my lord, because they may not be necessary party.
We'll try to dispose of the matter on the next date of listing itself.
Yes, my lord.
But no stay can be there.
We will take a date in the trial court, my lord, may kindly make an endeavor to dispose of the case on the next date, my lord. It may be, my lord, may make an endeavor to dispose of the case on the next date.
But
my lord.
obviously, the sole respondent's notice has to be served first.
Yes, my lord.
You are Mr.
UK Burma.
UKK Burma, and Mr. UK Burma. Elected in the counsel for the petitioner and also heard so and so. Oh, no, so and so no. It's the only sole respondent. This is an application under section so and so against DTP case number so and so. For questions in GSL here. Issue notice to the sole respondent to register AD and as usual process. And also call for the scan copy of the case record of so and so from the London court of so and so. And this the letter after 4 weeks and the endeavor shall be made. Endeavor shall be made to dispose of the matter on the next date of listing on appearance of the respondent. Okay, I have made the observation that on appearance of the respondent, the endeavor shall be
Can
made
there
to
be a stay
dispose
till
of.
next date, my lord? Till next date only. Can there be a stay, my lord?
No stay, no stay.
Deep leveling.
Four weeks, list after 4 weeks.
Deep leveling.
24.
Is the impugned orders, lordship, at page
Page?
9, 10, 23 and 5, 12, 23 by which NGW was issued.
No, page number.
Page number, lordship. 14 and 15. 9/10/23, NBW was issued. Thereafter, on 5/12/23 also NBW was issued. And
You
proclamation
are
was
Yusumi Goimari,
Lordship,
Goyari.
Guari. Now, I have stated in para A, the fact why I could not able to appear. And there was a
No,
title
this is the order of 9/10/2023.
23 and
Prior to that, you were appearing.
no, I never appeared.
Or you never appeared.
Never appeared. Because
Then?
if your lordship comes to paragraph 8, page 5, here I have stated why I could not able to appear. Even the title suit D filed by my husband, that in that case also I could not able to appear, and as such ex parte order was passed. Because I was confined by my husband in Udalguri. I am a resident of Chirang, Bijni, but my husband confined me in Udalguri, which is 250 kilometers away. That I have stated in paragraph 8. Lordship. Married law, right. That the petitioner begs to state that her husband, C. Viren Goyari, filed the title suit D being number 35/2023, and after filing the title suit, the petitioner was forcefully kept under confinement in the house of one Mrs. Niru Bosumatari, Udalguri town, so that is 200 kilometers from Bijni town, till the ex parte judgment dated 22/10/2024 was passed. As such, she could neither appear in the title suit D, nor she was aware about the issuance of summons by the Court of Learned as JMFC Bijni in case number PRC 175/2022. Now, after that ex parte judgment was passed, Lordship, this is the ex parte judgment. Then only I was released from the confinement, Lordship. And thereafter I came to know that police was searching me, Bijni police was searching me in this PRC case number so and so. And now I want to appear before the JMFC.
But the title suit was filed by your husband.
Yes, Lordship. And he confined me because he wants to get rid of me. Therefore, he confined me in Udalguri in one Niru.
No, why? It is a property dispute or what? What
No.
kind of title suit?
Title suit was for decree for divorce.
Decree on divorce?
Yes, ex parte. He wants to get the ex parte so that I cannot appear or contest the title suit D.
In the present case, my lord, FIR is at page 12.
Yes.
FIR is at page?
Page 12.
Yes. And what is the content of the FIR, Lordship? Is it absolutely purely a civil? Page 12, Lordship, 11/8/2022. With due respect, I would like to inform you that accused so-and-so, daughter of so-and-so, and Bijni Chirang, and one so this is the petitioner, wife of Biren Goyari of so-and-so, so-and-so, with an assurance of providing land to me, took money from my account to an account provided by the accused, totaling to an amount of rupees 1,90,000 at different times through YONO SBI app starting from 15/11/2021. In addition, I have also paid an amount of rupees 5 lakhs in cash, but till date they have not handed over the land to me or returned the amount of money.
But the Biswajit, the Biswajit কি হবে?
Biren.
No. FIR was lost by whom? Boheti.
Boheti Bosumatari.
Boheti Bosumatari.
Lost the estate.
But she is not related with this husband or her.
No.
They're separate person.
They're
Different person.
They're separate.
Anyway, my lord, otherwise,
Both the
on
accused.
the contents of the FIR, if she wants to appear, my lord,
Yes,
let
I'll
him
appear.
appear, no, fix the thing.
I'll appear.
Otherwise, my
So
lord,
you are shown as an absconder in the charge sheet.
Yes. No.
Charge sheet?
In charge sheet, it was split out. Lordship. Lordship, I have elect the order, Lordship. Okay. After proclamation, Lordship will find at page 17. 17, order dated 17/9/2024. The accused person so-and-so is absent without any step. Attachment issued against the accused person returned with report that the accused person could not be found there, and there is no property in the name of the accused person, hence order of attachment could not be executed. I've had the additional PP, APP.
No, I understood. These are the orders NBW were issued and you were
The proclamation.
subsequently proclamation was issued. Now question is that whether you have shown absconder in the charge sheet?
No, 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 no.
At
Because
that time?
it was split out, Lordship. The SSD
No, no,
is the
split it out is different question.
trial, instant case is split up against the accused.
Split up, I am not on split up, I am on search sheet. What was the search sheet?
Charge sheet, Lordship, it is not with me, Lordship.
Whether she was shown absconder in the charge sheet?
That I.
How can we say? The splitting up is a
There
different
is no
aspect.
statement regarding that, my lord.
Lordship, there.
And the such-
And the other, I mean,
Other
the
accused person is the my lord, husband of the present petitioner.
other accused is the
Husband of the present petitioner.
husband can I go?
Yes, my lord, Laju, inform you that accused Laju Gowari.
Laju Gowari is my sister.
Oh, yes.
Laju
yes,
Gowari
I-
is his sister.
Is my sister.
Sorry.
They have not, I mean, supported the, all the order sheets also, na?
No.
We don't have anything. Only from 9/10/2022 you have annexed some order sheets.
Some, yes.
Annexed order sheets, how can we know that?
Let him annex all those on the same.
And this charge sheet also, charge sheet also. You
Charge
add this, annex this charge sheet. Your ground is, okay, you may be confined, how can we appear?
Yes.
That is okay. But without anything, how can you pass? It's not here.
No, I'm only on this impure two that NBWA issue because
No, to that only, we need something, na?
there are. Earlier
Where? Where there are?
Earlier also NBWA was
There is
issued.
no statement regarding whether.
24/7/23 also NBWA issued.
No, you have not annexed the charge sheet, you have not annexed the previous orders. The order you have annexed is the only on from 9/10/2023. So how can we know that?
Thereafter proclamation, thereafter no. Charge.
File a press petition, my lord, by state.
No, you annexed along with the order sheets,
I'll file
complete
an
order
additional
sheets and
affidavit.
the charge sheet also.
I'll file an
You
additional.
annex with the, through an additional affidavit.
Yes, sir.
When can you file?
By Monday, Lordship.
Monday, lots of matter be fixed. Monday,
That
Wednesday,
Tuesday.
okay, Tuesday, okay. Heard Mr. Ardhur, Ilanit Council for the petition. So and so corrigible. Release the matter according to 25/3/2025, enabling the petitioner to file the additional affidavit to bring some documents on record. List accordingly. Okay. You need this one? Use a
Yes,
certified
okay.
copy, I think. But that's understood, the ex parte order was
Yes,
obtained
yes,
by
yes.
him. And ground which I mentioned that the confining her in a
Yes.
room, that is also there.
Explain, madam. These two persons might have committed page 13 in the FIR. These two persons might have actually, they are the middle person. Informant party has gone to them for settlement of the matter. While coming back, my lord, the other party attacked these people. Now, this is the case, but page 13 just 17% named in the FIR. And your
Where they have gone?
17% named in the FIR.
Huh.
Now you will kindly see, madam, only my lord. With due respect, on 2/3/25 evening at 5 PM, altercation took place between my son Zahidul Islam and co-witness accused number 1 regarding the issue of a driving of a vehicle. And accused number 1 assaulted my son and left the place threatening to kill him. On receipt of the information, I went to the house of my son and with a view to settle the dispute amicably. Now, I, along with co-witnesses, Kangan Hussain and Muslimuddin, went to the house of accused number 3, petition number 1. Your lordship kindly note. So informant along with co-witnesses has come to my house.
You are accused number 3.
I am accused number 3. Accused number 3, after having discussion with accused number 14, petition number 2, this 3 and 14 are before lordship. Now, my lord. Your lordship.
We are before 3 and
3 and 14.
3 and 14.
14. So their case matter, they have gone to our house, accused number 3 after having discussion, sent back us with assurance to settle the matter on 3/3/25. Petition number 1 is the elected president, number 2 is also member of the Panchayat matter. So they are
village headman, my lord. That's why they have gone to their house. And this petition number 1, called petition number 14, he is far away, my lord, 3 kilometers away his house. With assurance to settle the matter on 3 so and so, when we were coming home from house of accused number 3, from my house, accused number 1, that we were coming home from the house accused number 3 at around 9 p.m. And as soon as I came back to the road, the other accused person with people and manner restrained us from all sides and attacked us with lathi so and so so and so. So this is the whole case, right now. The rest thing, my lord, allegation is on those persons, but we have been implicated only because they have gone to our house. They might have thought that we might have instructed them, maybe that is, but it is not there, my lord. Only because of that, they have gone to my house, that is true, my lord. The rest, nothing, no involved. So my question, my your worship, may call the city matter in the meantime. They are also, my lord, village headman, my lord, both the persons, my lord. Thank you. Subject to what my learned says.
Yes.
And when the last line at present, the injured persons are fighting with their.
Yes.
Anyway, my lord.
Heard Mr. H.R. Chaudhary, the learned senior advocate, assisted by Mr. M. Hawk, the counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioners are innocent and they are no way involved in the alleged offense. Full stop. It is a fact that both the father of the victim came to the house of these 2 petitioners to settle a dispute, but thereafter, and they also gave assurance for settlement, and thereafter they have not. And only no settlement. Apart from this, there is no allegation against the present accused petitioners. However, they are ready and willing to cooperate the IO in further investigation of this case if they are provided with some interim protection. Allow for it. Okay, will be under interim protection.
Will appear, my lord, within.
Yes, within 7
days.
days and then. Yes, and can be
24/4.
24/4. My lord, I remember item number 30 and 31. That's Rajasthan case, my lord.
Huh?
That Rajasthan vehicle is for
It
Rajasthan.
won't reach. I
What?
think it won't reach.
My lord?
It
Not
won't reach.
That's what I'm saying, man.
Uh-huh.
So it may be fixed any other day. That is what I'm saying.
Okay, we'll
That's
try.
why
Oh.
we are fasting on the way to go, my lord.
Yes, obviously.
30 and 31.
Because some bail hearing matters are listed, that will be
It may
admission
take
matter.
time.
But
This also
admission
might
matter
take
will
some
not
time,
reach.
man.
Right.
Any day, my lord, the only interim is there.
30 and 31.
30 and 31.
Oh, that Rajasthan wala.
Not Rajasthan wala.
Interim was there?
Yes.
Due to positive corridor. Hard sense of corridor due to positive time sense of corridor. This is also assisted by you also. Mr.
Yes.
UK Borman, I think.
SS
SSGR.
SS Ahmad.
SS.
Ahmad.
SS Ahmed name is not here.
Name is not there.
Achha, anyway, SS
Any
Ahmed.
Ahmad.
To continue corridor. Interim be continued till next set of listing corridor. Yes, Potakur. It's a
So, my lord,
7th of April.
7 or 8. Anyway.
next week, my lord, if possible.
Next week, not possible. 7th or 8th, you are divo pari 7 by 8. 9th. She's suggesting 9th.
Yes.
9.
Okay, 9th.
9/4.
9/4.
Interim.
Interim will be there.
Obliged.
May I please the corruption? FIR is at page 8,
Page 8.
8. So what happened, my lord, there is this accident, my lord, and most of the police officers of Silchar PSS rushed to that place of occurrence. An accident was there.
Oh, accident was there.
Yeah, took place, and most of the officers of Silchar PS have rushed to the spot, the place of occurrence, and accordingly, Halla was there, and the accuser have been implicated in the case. May I read my FIR? Page 8. In inviting the reference cited, I have the honor to report that today on so and so an accident case was reported at Silchar PS Traffic Branch Silchar over telephone in the area of Singari, Chankuri Road in front of GP office. Immediately, I, along with available PS staff, including Inspector Amrit Singh, OC, Silchar PS, Inspector Vipul Soikia, City Inspector, Silchar, SI Santanu Das, IC Traffic, SI Subhajit Datta, Traffic Sub-Inspector of Silchar PS, rushed to the place of occurrence. In the meantime, found some unknown and unidentified miscreants were obstructing police personnel while performing government duty by taking advantage of road traffic accident in between one truck bearing registration number so and one bicycle, and they were trying to vandalize our government issued police vehicles which were issued by government in the name of traffic branch Silchar. While I, along with available PS staff of Silchar PS and traffic branch, obstructed them from doing this type of unlawful activity, but the below named accused persons leading with others became more aggressive and fast and through slang languages, photos employees here with and started to assault to engage police personnel. As a result, the driver of Artiga vehicle, namely so and 8G Deepak Das of Silchar PS traffic branch, sustained injuries. The on-duty police team somehow managed to save both the injured police personnel and immediately shifted to Santosh Mohan Dev Hospital for better treatment. Immediately, one person, namely Vrindavan Sinhan, so, have been apprehended and brought at PS for further investigation and identify another co-accused persons who were able to manage to fled. They were taking the available advantage of hue and cry situation. So I humbly pray to you take legal action, so. Now, in the list of witness, well, I am for accused this Batul Sinha and accused number 3, Monku Sinha. They were just, my lord, name has been given, my lord. Actually, in the name, the list of accused, this Vrindavan Sinha, who has been apprehended, he is not there. All the affair, it's my lord, seems and all the police officers have run to the spot. Some halla will be there, my lord. Villagers has come out. And these are the young boys, my lord, unemployed youths. They have been named in the FIR. I think that nothing from them, even they have given for better. This is civil hospital, only civil hospital at Silchar SM hospital. For any medical checkup, they will be sent those driver of Artiga and head constable. These are young, actually. These are
Young boy, these are young boy. That's why today took part.
Halla was a big accident. Your lordship has seen all the police officers have gone to the spot. I think something was there. Some halla, big halla was there. How could they understand the name of so and so? Because Vrindavan Das they have been apprehended. Now these Vrindavan Das is not in the list of accused. Your lordship will find.
So, my lord, why all police officers went there to rescue the victimized persons, and these accused persons, my lord, not only attacked
Not
the
to
police
rescue,
personnel, also
nothing is
vandalized
there.
their vehicles, my lord. And now the present petitioner named one Vrindavan Das, my lord. So they know who assaulted, my lord. And they were also present at that point of time, involved in assaulting the police personnel and vandalized the vehicles.
Vrindavan is not accused. He is not, my lord, naming the accused, list of accused. This is something that Vrindavan Das has been picked up by the police from the spot. After that name and collected from Vrindavan Sinha or somewhere, we do not know. And there is no source also given. Who has assaulted so and so? Who has no description is there. That Batul so and so have assaulted the driver, assaulted the head constable. Nothing is there. Just naming have been mentioned. Till report of city, there may be enlarged on in the till receipt of city, because nothing. No, there so and so has assaulted, so and so has obstructed from discharging duties of police personnel.
They never involved in rescuing the victimized.
Nothing is mentioned.
Hospital, but rather they involved in fighting with the
Yes.
my lord, police, and they
That
are from
is, nowadays these are
these are the my lord, situation in all accident cases. My lord.
Till receipt of city, there may be, my lord. After this going through the CD, your lordship may reject that bill. Till, man. Only two we have come. This number one Batul, even They even don't know their name also. My lord. These all are his nickname. This Batul, actually his name is Santu Sinha, son of so and so, so and so. Then Monku Sinha, his name is Monkumar. Father's name also not similar. Still
What to
receive
say,
the case direct.
somehow collected.
Yes, let them appear on second.
Heard
They will
Mr.
appear.
B. Sinha, deadline counsel for the petition. And also heard Mr. P. Botaku, so and so. This is an application of section so and so in connection with so and so. Mr. Sinha, the learned counsel for the petitioner, submitted in this regard that when an accident took place on the date of incident, there was a big chaos and the large numbers of police personnel when visited to the place of occurrence. The villagers were also present and there was a chaotic situation. And someone might have damaged the police vehicle, etc. But these accused petitioners are no way involved in the alleged offense. But further, he submitted that from the FIR itself, it is seen that one Vrindavan was arrested in connection with this case, but surprisingly, the name of said Vrindavan is also not listed, is also not named in the list of accused persons. However, these accused persons are ready, accused petitioners are ready and willing to cooperate DIO in the further investigation of this case. And if they are granted with the privilege of interim pre-arrest bail. Mr. Botaku, the learned additional PP, submitted in this regard that to know the involvement of the present petitioners, the CD will be required, and accordingly he insisted to call for the case diary. Okay, DD board. Hope you will be under interim protection.
All right.
Appeal
Lord.
before the
Hi,
IO
Lord.
and cooperating. 24/4 will do.
Yes.
Oblige.
27.
Yes. This is an application.
In this case, special.
This is an application under section 482, Your Lordship. In connection with complaint case number PB01 of 2025 under section 9, under section 9, 3949B, read with section on protection of wildlife activity. And this case is pending before subdivisional judicial magistrate business.
Case is pending.
Yes, Lordship. That complaint case was lodged by the Office of the Forest Range Officer, Panbari Range Manas Tiger Reserve, Borpeta Road, Your Lordship. They have filed this complaint case before the SDGM court, Shirang, Your Lordship. SDGM business Shirang. That complaint case is at page number 13, Your Lordship. May I read this?
As page?
Page number 13.
13.
Yes, sir.
Yes.
Yes, Your Lordship. Office of the Forest Range Officer, Panbari Range, Manas Tiger Reserve, Borpeta Road, so and so. Memo number so and so, dated 22/2/2025 to the Honorable Subdivisional Judicial Magistrate, Business Shirang, BTR Assam. Reference number OR number PB/1 of 2025. Subject complaint. Complainant Bimal Hasda, Forester, Panbari Range, Panbari Manas Tiger Reserve. Accused is Sadhin Narjari, and accused number 2 is Anshul Narjari, and accused number 3 is just his title is there, Chetri. Date and time and occurrence 21/2/2025 at about 2:50 p.m. Place of occurrence, house of the accused number 1. Offense committed under section so and so of Wildlife Protection Act 1972 as amended applicable. Lordship, thereafter the brief of the case is that, Your Lordship, may I read at point number 2, that the complainant begs to state that for the last couple of days, a team of forest officers of different forest division kept working to detect some wildlife contrabands and to apprehend the culprits. Yesterday on 21/2/2025 at about 1 a.m., the team of the operation started in its mission and reached at village
Ayodhyapur under Harisingha Police Station, District Udalguri. The team raided the house of the accused and able to detect 2 numbers of elephant tusks and also apprehend the accused. Both the elephant tusks were seized there at about 2:55 p.m. and on being asked, the accused told the names of accused number 2 and 3 who were there in the nearby house. Immediately, without going any delay, the team rushed to the that place accompanying accused number 1, but unfortunately, the accused number 2 and 3 were already escaped from there. Within the situation went and so chaotic that the team rushed to Paneri police station accompanying the seized materials and the accused number 1. Considering the situation, the seizure list could not be prepared at the spot and it's prepared at Paneri police station at about 3 p.m. That the complainant begs to state that thereafter on another input was received and some of the team rushed to place near Harisingha Bridge and found the vehicle by which the accused number 2 and 3 came there. Immediately, the vehicle Maruti Wagoner registered number AS 26Z4933 was seized there at about 5:15 p.m. and has been kept under safe custody of IC Nunoi Range. The complainant begs to state that being it a case of Manas Tiger Reserve, the accused and the seized materials were brought to the office of Field Director Borpeta Road for onward necessary action. The team reached at Borpeta Road at about 10 p.m. and being at night, the accused was provided necessary food and other and then kept in the safe custody Borpeta police station for the night. However, Your Lordship, I'm not going to every details of this complaint case, Your Lordship. However, they prayed before the SDCM court to take necessary action against the accused person. And immediately before Your Lordship, the investigating authority as well as the office of the forest authority produced the said accused person Sadhin Narzari before the SDCM court, and accordingly he was sent to the judicial custody. Thereafter, the investigating authority arrested 2 numbers of accused person, Dilbar Bhegra and Ahon Bosumatari, which is at page number 18, Annexure 3. The 2 accused person, the Dilbar Bhegra and Sri Ahon Bosumatari. Now, facts of this case is that, Your Lordship, that the seized vehicle, which has been seized by the investigating authority from the Harisingha overbridge, that the said vehicle is the owner of this present petitioner. Basically, my lord, the petitioner in connection with this bail petition, he is a driver and he is the owner of the said seized vehicle. My lord, on 28th February, one accused person named in the said complaint petition that Anshul Narzari, accused number 2, Anshul Narzari, in the complaint petition itself, they are reflected that Anshul Narzari is also belongs from his place, Sirang district, Your Lordship. He came to the said petitioner's house and asking for and hired his vehicle. Thereafter, he agreed that yes, I'm going with you with the said vehicle to drop you in Udalguri. Thereafter, Your Lordship, he stated that the said Anshul Narzari stated in front of him that you need not go to the said place. You just hand over the vehicle on rent. Thereafter, he directly stated that
without anything, he handed over the vehicle.
Yes,
How?
Lordship.
Without knowing a person, he handed over the vehicle.
No, Your Lordship. He actually he used to give the he used to drive the vehicle on rent, Your Lordship, on trip actually.
No, you're saying that he is the owner driver of the seized vehicle.
Yes, Lordship. Yes.
Again, you are saying that he handed over the vehicle
Yes,
to
because
accused number 2.
on the prior date, on the prior date of this incident occurred, Your Lordship, on 28th February 2025.
Whom he delivered the vehicle?
My lord, did that Anshul Narzari, Your Lordship.
Why?
On rental basis, Your Lordship, here.
Rent.
Because his livelihood is that, Your Lordship, to drive that vehicle along with whoever came to him, Your Lordship. Thereafter,
No, he is a driver. He ought to have carried this, the said accused, then
No.
why he delivered the vehicle?
yes, Lordship, it's correct, Your Lordship. However, he doubled the fare. And thereafter, he hand over that vehicle that yes, you can go, you can take my vehicle. Thereafter, Your Lordship, when he went to the Udalguri, in the midst of the Harisingha bridge, he called over from that present petitioner that your vehicle is broke down. Thereafter, he came to know that
thereafter the said accused person switch off his mobile phone and asked him that do you bring your vehicle coming to the said Harisinga bridge, your lordship. And now your lordship, now the investigating
Now,
author,
once you have said that your vehicle has been broke,
yes, that
Then?
the said Anshul Narzari told him over phone that your vehicle was broke down, your lordship.
then whatever, broken vehicle, how it could be taken out? He again brought the broken vehicle.
No, your lordship. He did not. He thereafter the police investigating authority earlier itself the investigating authority seized his vehicle, your lordship.
No, it was vehicle was seized near that bridge.
Yes, lordship.
When, where, how it was lying there, was lying there? The vehicle,
Because-
how?
Because Anshul Narzari.
Who parked this one?
Because
Anshul Narzari.
Yes, your lordship. Anshul Narzari left that vehicle. As far the instruction is concerned, your lordship, he left that vehicle in the Harisinga bridge itself, your lordship. And thereafter the investigating authority seized the vehicle and in connection with this case, your lordship. And now he is apprehending in connection with this case. He filed this bail application before this honorable court seeking anticipatory bail. My lord, your lordship.
So complicated. Yes.
My lord, the offense involves elephant tusk. So my lord, interim, and he has been absconding also. So interim at this stage may not be given. I'll take instructions and see what the IO has to say. My lord, then.
Case is still under investigation, I think.
My lord,
I'll have to take instruction, lordship, the state, because we have just been served a copy today.
Because in the complaint itself, which was lodged before the SDGM,
Yes, lordship.
there itself it was mentioned that one person named Chetri is also involved.
Yes.
That may be the person, this Bahadur Chetri or whatever.
And
So
the
that
car
was there in the,
seized,
yes,
through which they tried to escape from what it looks like.
yes. Now he is saying that he is the owner and the driver of the vehicle, again delivered the vehicle, again was carrying him, was on hired the vehicle, then delivered the vehicle.
Some sort of nexus is there.
I don't know. I don't think it will be a proper case, I think. Let the case diary be called for and you take instructions also. You don't think it is a case of interim. Because things are there that I don't know how a person without knowing anything, he delivered the vehicle to him, it's just you take away my vehicle. That I mean, it's not thing. Yes, he may be a genuine owner or driver of the vehicle. I'm not on that he may not be involved also.
Yes. It's a fact that he is the owner of the said vehicle, which was seized by the concerning authority, your lordship, the forest authority.
Have you
It's a
filed
fact.
any JIMA petition also? No.
No.
Because you are now.
Because
absconding.
he is a.
Okay, then we'll call for the case record and case day. We also take the instructions. Call for the case record. Heard Mr. I. Botaku, Learned Standing Counsel, Forest Department. Also heard Mr. S.D. Roy.
Yes,
So and so. For the petitioner. Call for the case diary and the Mr. Botaku will also take the necessary instructions in this regard. List accordingly when it can be listed. And before Bihu, don't give it before lots of many patterns have been fixed before Bihu. After Bihu, it will be proper, I think, after Bihu. Immediately after Bihu, which is your reopening day? 21 is our reopening day, so let it be on 22nd. 21 it may not reach also, 22nd.
Much obliged.
Okay.
And name of special PP wildlife may be reflected in the cause listing.
We have reflected your name. Oh, we made direction maybe. Okay, okay. The registry is accordingly directed to reflect the name of special PP wildlife. So now you are appearing as a standing counsel forest or special PP?
On behalf of special PP wildlife.
Mr.
D. Gogol.
D. Gogol. Mr. D. Gogol can appear as a special PP wildlife. Mr. Ayappa Thakur is appearing on behalf of special PP wildlife, Mr. D. Gogol. And registry is accordingly directed to reflect the name of the special PP of wildlife on the next date of listing. Okay, we'll next.
Mid please, Lordship. Lordship, this matter had came up on 19th, previously on 19th before the court. Lordship, there were some discrepancies with the FIR, copy of the FIR. Your Lordship has directed me to.
Oh,
serve a
that it was not in proper presentation or something,
Lordship.
yes, such.
So I have served the copy of the FIR, Lordship. Lordship, what has happened in this matter is.
You have already received, but what happened in
Yes,
the
ma'am.
last
Copy of
occasion?
the FIR is there.
There was this FIR and there was some discrepancies in
Yes.
furnishing the copy to the
Yes.
the state. We don't going to hear the matter at length, just short submission will do, otherwise it will get.
Lordship, interim protection may be granted to me since Lordship, no allegation has been made against me, no specific
For
allegation.
interim protection, we have to hear, how can we give interim protection? Yes, tell us. Yes, you can submit.
Lordship, I will just confine my submission very shortly. Lordship, respondent number 2 has got married in the year 2007. After 7 years, I have got married in the same house.
Oh, yes, yes.
Lordship, before my marriage, respondent number 2 had shifted to Jorhat, and after my marriage, I had been living in Nokha, Rajasthan since.
No, prior to your marriage, you were there along with?
Prior to my marriage, the respondent number 2 was living in Jorhat only. She was not staying in the same house in the Nokha, Rajasthan. After I got married. Subsequently, Lordship, there is no specific allegation against me. We are not residing in the same house.
You are sister-in-law?
Yes, Lordship. And Lordship, there is no.
Just a second.
Yes, Lordship.
So you are the sister-in-law of Purnima Rathi and you are just saying that prior to your marriage.
Prior to my marriage, the private respondent number 2 had already shifted to Jorhat. And
you are not staying with her.
We are not staying together after my marriage.
After your marriage, you were not staying together, but prior to your marriage?
Prior to my marriage only, she was shifted to Jorhat only, Lordship, for work. She was doing work in, she and her husband was doing work in Jorhat.
Prior to your marriage?
Prior to my marriage. And when I got married, I was living in Nokha, Bikaner after that, ever since.
So prior to marriage, where you were staying? Prior to your marriage, where you were staying there, they
in Rajasthan only.
In Rajasthan.
I am born and brought up in Rajasthan. I got married in Nokha, Rajasthan only. And she was working and since 2007, she was living in Jorhat only.
So you were staying at Rajasthan?
Yes, Lordship.
Prior to your marriage?
Yes.
And after your marriage, you shifted to Nokha? No.
Lordship, Lordship, the private respondent number 2 herein. She has lodged an FIR under section 498A of the IPC against all the family members.
Yes, that is understood.
Yes, Lordship. Lordship, respondent number 2 got married in the year 2007. After she got married, she and her husband have been working and living in Jorhat, Lordship. Lordship, I have been married to the brother-in-law of the respondent number 2, and I have been living in Nokha, Rajasthan. So we both are not residing. We both are not residing together since my marriage. And before marriage, I did not even knew her, Lordship. Lordship, what has happened is the allegation raised by the respondent number 2 in the Jorhat police station is that there was a demand for dowry, there was a harassment, and she was not provided with medical treatment or whatever the allegation was raised, Lordship. Lordship, my humble submission is in the entire FIR, there is not even a single allegation or specific allegation raised against me, Lordship. Secondly, Lordship, there was a prior, before she shifted to Jorhat and filed a FIR in the Jorhat, Lordship, she had already filed an FIR in the Nokha police station, Lordship, wherein she has accused all the family members except me, Lordship. Lordship, in the Jorhat police station, I have been arraigned as an accused number 5. And in the Nokha
in the earlier FIR filed at Nokha, you were not
I was not
accused.
Even. And there was no mention. And it was also filed under section 498A of the IPC itself, Lordship. And Lordship...
there may be subsequent development.
Yes. Lordship, there's, if your Lordship will look upon the Jorhat police station FIR, there's not even a single reference of specific allegation has been made upon me. The respondent number 2 has made all the allegations against all the accused except me, Lordship. Now I've been, after 2 years, now I've been simply made a arraigned as an accused, Lordship.
Okay, what is the stage of the case at present?
Lordship, investigation has been going on. There's no charge sheet been filed yet. One of the accused has received a 41A notice. And Lordship,
So we cannot stay investigation on that, Your Honor. I thought that it is a charge sheeted one. It's not charge sheeted.
Lordship,
So investigation cannot be stayed.
Lordship, interim protection may be granted to me since I've been living in Rajasthan.
No, why you have not, I mean, applied for any anticipatory bail also?
Yes, Lordship.
You have applied for.
No, Lordship, I have not applied for any kind of anticipatory bail in the court. Lordship, since I'm making out a prima facie case, since I have not been living with her ever, I have we
No,
both are not
whatever. The
deciding
question
to
is that we are not going to stay the investigation. That is not our part. The question is that if you want any protection, that is different aspect. But why don't you apply for any anticipatory? Because for your safety only.
Yes, Lordship. The Lordship that we will do it, but Lordship, my submission is that a suspension of investigation may be done only in respect to me because Lordship, if 41A, Lordship, if 41A notice will be served to me, and if I will be asked to come from all the way from Rajasthan to Jorhat, Lordship, first thing, Lordship, usually very short period of time has been granted in 41A notice to come, Lordship. And Lordship, I am a married housewife, Lordship. I'm not that educated as well, Lordship. It's very difficult.
Without describing any merit of the case, without any investigation, you want that your case should be quashed against?
Only until, Lordship, only until the.
Yes, Bhattakur, any other?
Let him file one anticipatory bail application regarding the
Fine,
petition.
it is
And in
up
this
to
case,
the
your Lordship notice may be issued and CD may be called for.
Lordship.
At best, let us see no corrosive action that kind of protection can be
Yes,
given.
Lordship. That may
But corrosive action doesn't mean that you will be debarred from appearing before the police station complying section 41. That will be not
I'll
there.
appear, Lordship.
You
I will
appear.
appear. Lordship, just I have a very small, humble submission. If your Lordship may consider that at least 15, 30 days time may be granted to me to appear before the court whenever a notice been issued because Lordship.
No, you are not going to appear before the court. You have to appear
before the police station. Sorry, apology, Lordship. Before the police station, at time, at least a reasonable amount of time may be granted because
No,
Lordship, I'm not
during this
economically-
period, whether you have received any 41.
No, Lord.
Till now, we have not received.
Not-
Then what I'm saying.
After this-
If during the investigation, the police thinks or if police finds that 41 may not be required to issue you against you also if there is nothing. Say suppose
Yes,
during investigation that may be a prayer from the high also
Yes.
to release you from the case itself, to discharge you from the case itself.
Yes.
That may be there. May not be there against you. There may not be any. You are Mr. KP Maheswari?
D. Rathi.
D. Rathi. अच्छा अच्छा कोर्ट कहाँ से है? Heard Mr. D. Rathi, Dilane counsel for the petitioner, and also heard Mr. P. Bhattakur, Dilane additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so for quashing of FIR and also that's next para. It is submitted by Mr. Rathi that the present accused petitioner is innocent and she is no way connected in the alleged offense. Further, he submitted that she never shared any household along with the respondent number 2. Prior to her marriage, the respondent number 2, along with her husband, had shifted to Jorhat. And after her marriage, the petitioner is staying at Nokha, Rajasthan, without having any kind of Nokha, Rajasthan separately. Further, he submitted that prior to the filing of the FIR at Jorhat police station, she earlier lodged an FIR in Nokha police station, Rajasthan, wherein she brought the allegation against all other accused persons except her and except the present petitioner. However, with the same set of allegation, the present FIR has been lodged in the Jorhat police station, wherein she has been added as an accused, though there is no allegation has been brought against her in the said FIR. However, he is under apprehension of and accordingly he submitted that till the disposal of the present petition, the investigation only in respect of the present petitioner may be stayed. Stop. Next para, Mr. Botaku did an additional PP submitted in this regard that the investigation cannot be staged at this stage. And accordingly, he insisted to issue notice on the respondent number 2 and also to call for the case diary. Next paper, আপনি আগতে issue notice করে দিব না? Considering the entire submission made by the learning counsel for both sides, let the case you here you need the case diary. No need to call for the scan copy. Case diary be called. Case diary be called for, and till next date of listing, in the interim, as an interim, the till next date of listing, no corrosive action shall be taken against the present petitioner. List accordingly. After when it can be listed, what happened? After 2 weeks, 3 weeks, list after 3 weeks.
Lordship, after Bihu, if
It will be complete. Will come after
after
Bihu only.
Bihu,
List
3
after Bihu vacation.
after 3.
Okay, list after Bihu vacation. And you take steps for the respondent number 2.
I'll do
Oh.
that. Deeply obliged, my lord. Deeply obliged.
Or other cases may be adjourned.
Well, my bail petition, my lord.
All will
Motion
be
madam.
adjourned now. I'm just
Kindly, my lord. Kindly, my lord.
no,
Motion,
no,
madam.
I'm just adjourning all the cases.
Motion,
What to
madam.
do?
One matter only, my lord.
You're is in motion.
My lord, that's all.
Acha, acha. Okay, then okay. Motion will be taken.
My
up.
lord.
Uh,
Other matters will be there.
One small prayer, my lord. Item number 47, my lord. I may be allowed to withdraw this petition with liberty to file a fresh, my lord.
Item number
47.
47. One affidavit was filed, in fact, in the morning hours.
One affidavit.
Someone, it was told by someone that one affidavit has been filed here.
That is filed by me, my lord. But in the meantime, my lord, I have been instructed, my lord. Another case.
You
is
got
filed
the
by-
other instructions.
Yes, my lord.
Okay,
This
you
is
are
my-
Mr.
D. Borua, my lord.
D. Borua. So you want to withdraw this one
Withdraw
with
with
liberty to
file.
fresh a file. With liberty to file a fresh. Okay, we are disposing the matter with a liberty to file a fresh.
Item 28, interim order will be done.
Okay, we'll listen after.
okay.
Yes, 43.
My lord. Page 18 is the FI, my lord. Varnacular, my lord. This FI is the counterblast of the FI filed by the wife of the petitioner number 1,
Make short submission.
my lord. Page 18 is the FI, my final.
Page 18.
Page 18, the Varnacular. যোৱা 14/3/2025 তাৰিখে আবেলি 3মান বজাত ঘৰত কোনো মৰ্তান মানুহ নথকা অৱস্থাত পদকীয়ে মোৰ ৰুমৰ ভিতৰত সোমাই মোৰ স্ত্ৰী মনিকা কৰ্মকাৰ জবৰদস্তি হলি ৰং লগাই কিন্তু লগৰ লগে মনোভাৱ লৈ গোপন অংগত হাত দিয়ে আৰু জবৰদস্তি কৰাৰ চেষ্টা কৰে মই উপায়হীন হৈ চিঞৰি দিয়াত পদকী এজন পলাই যায় সন্ধিয়া 6টা বজাত মই যেতিয়া ঘৰত আহোঁ মোৰ স্ত্ৰীয়ে ঘটনাটোৰ বিষয়ে মোক জনায় এই বিষয়ে পদকীয়াজনক মই যেতিয়া ফুটপুচ কৰিব যাওঁতে 1 নং 1 2 3 নং আছামী মোৰ গেটৰ সন্মুখত পাই ফুটপুচ কৰাৰ লগে লগে পদকীয়াই দৌৰি গৈ ৰড আনি বেলচা আদি আনি দাদা বিনন্দ চৰকাৰ বেলচাৰে মূৰত মাৰি ফালি দিয়ে ভাইটি নিত্যানন্দ ৰডেৰে অনিৰুদ্ধ মৰাঙে মাৰি মূৰ ফালে 3 নং পদকীয়াই ভাবুকি দিয়ে যে ঘটনা থানাত জনালে তেওঁলোকক মাৰি নদীত পেলাই দিয়ে kindly peruse my the FIR filed by the wife of the petitioner page
So
25
this is the FIR
My lord.
against you.
against you and
But
this,
why
this
it
is
is
filed
there that-
subsequent due to
No,
the-
just a second. It
Right.
is here that মই উপায়বিহীন হৈ চিঞৰি দিয়াত
My lord.
পদকীয়া জানি once you are saying that উপায়বিহীন হৈ you are চিঞৰি দিয়াত and then again you are saying that
this is the
যেতিয়া ঘৰত আহো মোৰ স্ত্ৰীয়ে মোৰ ঘটনা কথা
yes, my
how it can be
well that is the they false matter my
no how acha this is
My
that
lord,
is
that-
their petition
that's
okay
page 25 is the FIR my lord against which that FIR has been lost my lord.
you lost an FIR on 25
yes my lord. On same day page 25 Varnakula I am reading now বিনীত নিবেদনে আজি সন্ধিয়া 6:15 বজাত আমাৰ সমীপৰ শ্ৰী উমানন্দ চৰকাৰ দা ইনফৰ্মেণ্ট আনন্দ চৰকাৰ আৰু ঘৰত তেওঁৰ আদি চৰকাৰে আমাৰ ঘৰত অনধিকাৰ প্ৰৱেশ কৰি শুই থকা অৱস্থাত মোৰ স্বামী পেটিশনাৰ নম্বৰ 1 এন নাবালক পুত্ৰ শ্ৰী শচীন শাহ আৰু এজন শচীন শাহ লু ৰড আদিৰে কোবাই বেয়াকৈ মাৰপিট কৰে লগে লগে বিনন্দ চৰকাৰ নিত্যানন্দ চৰকাৰ অৰ্চনা চৰকাৰ আনন্দ চৰকাৰ all the family members of the informant
পৰিয়ালে আহি আমাক মাৰপিট কৰে। মই শাৰীৰিক অসুস্থতা তথা অপাৰেশ্যন কৰা বুলি কোৱাৰ অৱস্থাটো ক্ষান্ত নহৈ মাৰপিট কৰে আৰু আমাৰ ঘৰৰ পৰা ডিঙিৰ পৰা চেইন আদি কাঢ়ি লৈ যায়। As a counterblast, that counterblast.
Your FIR is registered as
As my lord, GD number kindly peruse my lord 231 prior to the FIR lodged by the informant.
your is GD 231.
231 and their GD is 233.
233.
232 my lord. 234 my lord, not 230. Page 19 my lord. Original certified copy. Everything is lost, my lord. Since the petitioner's wife has filed petitioner number one's wife has filed this FIR, my lord, to protect themselves, my lord, that FIR has been lodged against us. This is the simple case, my lord. The lordship kindly call for the case diary and in protecting the petitioners, my lord, and if there is any material, lordship may dismiss the bail.
Injuries were what kind of injuries?
Well,
Which is it?
there is no injuries, my lord. They have attacked us in our house, my lord. In my house, my lord. Petition number 1 house.
No. Injuries, left about injury. What is the allegation of injuries?
Injuries they allege, my lord.
These are the injuries are falls under which section?
Yes, otherwise,
Well, I'm
case
just
diary
confusing
will
that.
reveal fact. Only the case diary will reveal.
No. Section, sir. 307, 326, 325, what are the?
Heart, my lord. Yes, heart, my lord.
Heart?
Yes, ma'am.
Mane?
Grievous heart. As per BNS, ma'am.
Yes, 117 was previous one.
117 is the grievous.
My lord, grievous heart, my lord. Heart.
Heart means grievous.
Heart, my lord. Only heart, my lord.
Only heart.
My lord.
How? Only heart?
Voluntary causing grievous heart, my lord.
Grievous heart. Why you are saying heart? It's
No, but-
grievous heart, not heart.
Yes.
117(2). Whoever except in the case provided for by section 1 and 2 of section voluntarily causes heart grievous heart shall be punished, my lord.
Why heart? Again,
My lord.
you are uttering heart. This is a voluntary
My lord.
grievous heart,
My lord.
not heart.
That is the FIR, my lord, counter blast, my lord. Of the FIR.
Heart boli kore ase. Yes, পঠা করবার to do.
Case diary will reveal regarding from the FIR it reflects that
They have attacked in my house, my lord. Then thereafter they file, my lord, as a counter blast to the FIR filed by the wife of the petitioner number 1, my lord. GD entry, my lord, reveals everything.
only injury report will reveal the actual fact.
Lordship kindly protects us, my lord, if there is any.
Mr. Secretary, Tilani counsel for the petitioner and also heard Mr. P. Waterloo, Tilani additional duty appearing on behalf of state respondent. Okay, this is an application, so and so. It is submitted by Mr. P. Secretary that counsel for the petitioner that the after lodging an FIR by the wife of the petitioner number 1.
Yes.
The present FIR has been lodged against the petitioners with some false and concocted allegation as a counter blast. No such incident had happened as alleged in the FIR. However, it is a fact that, rather, the informant and husband of the informant and his other family members came to the house of the petitioner number 1 and assaulted them. However, all the petitioners are ready and willing to cooperate the IO in further investigation of this case. Granted, kiba kori diba. CD call kori diba along with the medical report kori diba. Whatever submission diba, insisted to call for the case diary. Yes. Call for the case
Till
diary.
then, my lord.
Okay, you will be under interim protection.
If there is anything, my lord, lordship may dismiss, my lord.
Your very fixed.
My lord, 22nd for
20?
22 for
22. 22nd of
Interim bail, lord.
interim protection. You will be under.
Obliged, lord.
No, I think 30th lordship, we did to the given lordship. I'm not in the interim lordship, long pending case lordship.
Fixed date?
Not the
Try
interim
to give
lordship.
any
Interim,
fixed
not
date.
the lordship. Lordship interim or.
Where CD is interim. Yes, it can be laid over without any order. And these 3 bail matters which were there, CDs, Kothapur, CDs, three CDs are there, na? Three CDs we are giving dates, some dates.
38, 41 and 40.
These are CDs are available.
Yes, 51.
So we are trying to provide the fixed date here. You have already received the case date, retained the case date, that will be the order. And we'll try to fix a date. But the question is that will not be prior read and all, because all that will fix and don't fix any date on 11th, or maybe on leave also. Side.
Lordship, item 28, Lordship, the interim order may be extended.
Okay, we'll see. Okay, we'll see.
Not 28, my lord. Not 28.